Good afternoon and welcome to the Appellate Division First Department. Most of you know the drill. We have over 6 hours of requested arguments. So I am going to ask you to ask for the time that you actually need, not the time that you want. Most parties have asked for 15 and 15. That's not happening. So please, ask for the time you actually need, not the time that you want. Understand the clock is for you, not for the court. So if my colleagues, you're so brilliant that my colleagues keep on asking questions, I let the time go, because I want my colleagues to be able to ask the questions they need to decide the case, okay? So don't fret if your time is cut short. Understand that, again, the clock is for you, not for us. If we have more questions, I will let the time continue. People versus Haram Rosario. Haram Rosario.
Good afternoon, Your Honor. Respond to request 5 and 2, please. Respond to request 3.
4 and 1 and 3. U.S. Bank versus 1226 Evergreen. You are here for?
I'm here for the respondent, Your Honor.
Okay, do you wish to submit?
Yes, Your Honor.
Thank you. Please have a seat and wait till the end of the call. People versus Gabriel Roas. Okay. 4 and 1 and 4. Thank you for listening. Haskins versus Metropolitan Transportation.
Request 7 and 3.
Good afternoon, Your Honor. Respond to request 3.
5 and 1 and 3. RDF Agent versus Electric Red Ventures. These cases will be argued together. So ask me tell me what time you want for both cases.
7 and 3.
Okay. 7 minutes. All right, 7 and 2 and 7. Rivera versus Sewell is a submission. People versus Twinalon Middleton.
Respondent request 5.
5 and 2 and 5. DssF Evanston versus Yen.
Appellate request 5 and 2.
Okay, seems you've scared away the respondent.
Respondent's here.
Oh, all right. 5 and 2 and? 5 for respondent. All right, 5 and 2 and 5. People versus Paul Pisano.
The appellant, Your Honor, 6 and 2, please.
Okay.
Respondent request 5.
All right, 6 and 1 and 5. Millennium Consolidated versus Bluefin Capital.
Yes, Your Honor. Appellate request 5 and 2.
Okay.
Your Honor, respondent request
5 and 2 and 5. People versus Omar Campbell.
Appellate request 7 and 2, Your Honor.
Okay.
Respondent request 5.
6 and 1 and 5. West 125th Street versus Chosen Realty Corp.
Your Honor, appellant request 4 and 4.
Good afternoon, Your Honor. Respondent Public request 4.
Okay.
Respondent Riverside Abstract request 4.
All right. 4 and 4, 4 and 4. AIG Property versus Arista Air. Okay.
Respondent 3.
All right. 5 and 2 and 3. Wilmington Trust versus Nelson.
Good afternoon, Your Honor. Appellant request 5 and 2.
Okay.
Good afternoon, Your Honor. Respondent request 5.
All right. 5 and 1 and 5. People versus State of New York versus Vidaire Foundation is a submit. First case on the calendar. People versus Haram Rosario. You may proceed.
Good afternoon, Your Honors, and may it please the Court, Aviva Galpert on behalf of Mr. Rosario. Mr. Rosario stood before the modification court, a 60-year-old man who had healthy, pro-social relationships, family support, significant mobility impairments and other disabilities, proof that he'd completed extensive sex offender treatment both in prison and upon his release, and a perfect record of compliance under his SORA and parole obligations. His risk of reoffense was clearly low, and his treating doctor attested, and the provident exercise of discretion would have resulted in a modification to a level 1.
Wasn't he already reduced from 3 to 2?
Your Honor, he was reduced from 3 to 2.
So you want a further reduction
We
from 2 to
believe-
1?
Yes, we believe a reduction to level 1 was appropriate, as this has been recognized in certain cases, and
Has been recognized by whom?
various courts, both at the modification court level and appellate level, have recognized that a modification from a 3 to a 1 may be
Why is the
appropriate.
risk of reoffense low in these circumstances?
The risk of reoffense is low in these circumstances for a number of reasons. Notably,
Other than his age, which we've rejected as a reason.
sure. Well, in addition to his age, his treatment is a critical factor in this case. Mr. Rosario was a survivor of child sexual abuse himself. He clearly had a lot of unresolved trauma. We don't say that that excuses his offenses. It does not, but it was a factor in his committing them, and so his treatment really significantly reduces his risk, as does the support that he enjoys from his family and other friends.
Didn't he
have
have
that
that
support?
Go ahead. Yeah.
Didn't he have that support when he committed the crimes?
Well, it's not clear that they understood the kind of support that he needed at the time, and now they do. And now, he has, he's no longer with his age-appropriate romantic partner, but he has had age-appropriate romantic partners since, and
He has had what?
age-appropriate romantic partners. And part of the reason that he doesn't have them is because his libido is so low.
I don't understand what that means. He has age-appropriate romantic partners.
He's been in relationships with adults, and he's still friends with them, and they understand that he may need additional support that he didn't have before. And I also would like to note that actually the starting level here should have been a 2. It should have been a downward departure from a modification from a level.
We are aware because the victim was actually 10 and not 11.
Well, the victim was 11, and there's no evidence in the record that he was 11, that he was 10, other than
So your
one
argument is that he should have been a 2 from the beginning.
Right, he was, exactly. And he was originally a presumptive 3 just based on 110 points, which is, of course, the lowest number of
Why
points.
is this case different than so many other cases where we have declined to reduce in very similar circumstances to this? Why is this case that exceptional case where we should overturn the discretion of the trial court and lower it?
Well, of course, as this court and Your Honor has recognized in People versus Jones just last year, it is appropriate for this court to exercise its discretion to
But when?
override-
It has to be something,
Right,
something
so-
unusual, not just any case. So why is this case
Yes, Your
different than
Honor.
the
So-
cases where we routinely don't grant?
Together with the plain misleveling in the first instance, we believe that Mr. Rosario's circumstances are exceptional, given the...
What is exceptional? He sexually abused his grandsons, both of them.
Yes, Your Honor, and
So what is exceptional about his performance in sexual abuse? What?
Well,
That wasn't already factored in.
the amount of training that he has undergone, both in prison, again, and upon release, the notes of his treating therapist, who found that he is extremely unlikely to reoffend because he recognizes and experiences deep shame for what he has done, as is appropriate. And
Am I
that he-
wrong that he didn't really acknowledge that he did anything to the second grandson?
He did acknowledge it, and he pleaded guilty.
Reluctantly,
I'm sorry, Your Honor?
reluctantly.
Well, there was some prodding needed. It was really, I think, a problem with the nature of the allocution. Pleading to attempt is often a little bit confusing for the defendant.
There's nothing confusing. Either you sexually abused your grandsons or you didn't.
Right,
Okay, I'm sorry. I really am. Because I believe that your client has already gotten a benefit by having one reduction. And it seems to me that time will permit a second reduction with a showing.
Thank you,
Okay.
Your Honor. We would note that if that's the court's view, this case should still be
I'm
remanded.
speaking only for myself. I don't speak for my
Sure, I appreciate-
my colleagues.
Thank you, Your Honor. Irrespective of his entitlement to a level 1, the case should be remanded so that the modification court can set forth its findings of fact and conclusions of law. as the
We have
statute
enough of a
requires.
record to make that determination ourselves, do we not?
I believe that the record enables this court to find that a modification to a level 1 would have been appropriate, indeed. But if this court isn't going to exercise its discretion to make a finding as to the appropriate level, then it should remand. Thank you.
Thank you.
Good afternoon, Your Honors. May it please the court. Noah J. Sexton for the people. I'm going to begin by
We don't
answering.
have to remand this case for findings, do we?
No, if you look at cases like Filkins, which is cited fairly extensively in the point that defendant was trying to raise about the specificity of the judge's determinations, the actual focus is on whether or not there is an adequate record to review on appeal. And clearly there is an adequate record to review on appeal because here we are reviewing this record on appeal. To answer Your Honor's question to my adversary, what is exceptional about this client? The answer is there is nothing exceptional about this defendant, about this offender. He completed sex offender treatment. Yes, nothing about any of the documentation that he's provided indicates that he was exceptional. On the contrary, he continued to minimize his guilt. And even now, he refuses to discuss this offense in any detail. He did deny that he did sodomize his youngest grandson. And the only reason he admitted that is because the judge said, I'm not going to take this plea if you're not going to admit to these facts. And then if we go to trial and you're convicted, given your age, you could go to prison for the rest of your life. It was entirely self-serving. It was not genuine. And there hasn't been any
And
acknowledgement.
even in the pre-sentence report, he refused to acknowledge guilt for the second child, correct?
He does. And now he's saying that, oh, my completion of sex offender counseling entitles me to further reduction than what I've already received. That was
But isn't the participation in that program already considered in the RAI?
It is. And
You would have to have some exceptional response to treatment in order for there to be an add-on.
Exactly. And in fact, he didn't really have a choice to complete sex offender treatment. He would have been penalized had he not completed sex offender treatment. So he's asking for a reward for the bare minimum. I will briefly speak to the age point. Yes, defendant is older than some of the defendants we see come through our office. He is 66. He is not 90.
What is your response to their argument that he has a better family support structure now than when he did in the past?
That seems based purely on supposition. I mean, there's nothing in the record that indicates that his family support has changed whatsoever. In fact, he might have had more family support before the offense, before he decided to rape his grandsons. But he did that, and now we are taking his word for it that his family is loving and supportive. That alone is nowhere near enough to justify any further departure. Unless your honors have any further questions, I'll ask you affirm.
Thank you. Counsel, you may proceed.
Your Honors, I'd like to briefly note that the SORA court appropriately found that there was no clear and convincing evidence that Mr. Rosario had failed to take responsibility or accept culpability for these offenses. He did plead guilty. The DA was willing to proceed.
You are not challenging that he had to be prompted, that the court had to tell him, unless you admit to these charges, we're not taking the plea. He did hesitate. He wasn't.
He hesitated, Your Honor. I believe that that was because of a misunderstanding about the element of force. There was also, this was being conducted with an interpreter. I think there was confusion. It was quickly rectified, and the plea proceeded. The court accepted it. The SORA court found that he'd accepted responsibility, and there was no concern at any point, really, subsequently, that he did not accept responsibility. He would have been penalized had he not done in-prison SORA counseling, but he did do it, sex offender treatment and counseling, but he did complete it also after prison, which was not self-serving. He did it, for the good of the community. It was self-serving to the extent that it helped reduce his risk of reoffense. That serves him, but it was not out of selfish motives.
But the PSI before, he did not admit to the other child.
In the PSI, there was an omission, but it's not clear that he denied it, and it's not really clear what happened or why that omission took place, or whether it just wasn't reflected in the PSI. But there's no record of denial or real failure to accept responsibility. And his doctor notes that the people note that he is now refusing to discuss it. That's not true. His doctor simply said that he was ashamed and struggled to discuss it, but he does persist through that shame, and he does accept responsibility in full. Thank you, Your Honor.
Thank you so much. Haskins versus Metropolitan Transportation.
May it please
You may
the court, Your
proceed.
Honor. Ralph Cosentino for the defendant appellants, the Triborough Bridge and Tunnel Authority and the MTA. I think the best way to sum up all the appellate arguments is that the record as it existed at the time plaintiff filed his motion did not establish his entitlement to Labor Law 240.
Why not?
It's a matter of
He
law.
falls through a hole in a dark space, on a hole that is covered by a soft mesh covering that's waterproofing and not a hard substance like a plywood.
You skipped a case.
We're on 5. We should be on 4.
People versus,
You did skip a case. This is
This is
Haskins.
Haskins.
Yeah.
versus Roas.
All right, we'll call.
Do you want me to
Rojas. We have
proceed, or
them
do you want me to
here.
sit down?
Yes, please proceed.
All right. This is just not a neat and clean 240 case like a fall from a ladder or a scaffold. This is a very fact-specific issue here. And the fact that nobody knows when the hole was created, why it was created, and it may have been created that day in connection to the adjacent retaining
It doesn't matter whether it was created that day. It was not covered properly.
But
You have to cover a hole with a substance somebody can walk on.
the record is not clear as to whether or not it could have been covered or whether or not covering it would have been impractical to the work that was created in connection to
It was covered, wasn't it?
There
with
was a
black
water
plastic.
there
at
was a
night?
waterproofing membrane over it, correct.
And you can't walk on that.
Well, the record,
So we've got a black waterproof membrane over a dark surface in darkness.
the issue of the lighting, though, I think is raised more, it's somewhat of a red herring, if I could use that term. Haskins and Galladay, his foreman, both said that there was sufficient lighting to perform their work, although they acknowledged that it was dark, and they talk about being dark. Galladay, the foreman, would not have allowed the work to have continued if he thought it was dangerous, and Haskins testified that the lighting was sufficient to do what he needed to do. The question is whether or not this was a work in progress and whether or not the covering would have been impractical for the work that had to be completed that day. There's
Was
no-
he covering the hole? Was his job to fill the hole?
The testimony,
Answer my question.
No, he-
Was his job to fill the hole?
the answer to that question is no.
So
that
then
was not-
how is that work in progress? Unless he has to fill the hole or fix something in the hole, and there's nothing in the record that says that.
The issue is that there are Rastani laborers that were supposed to be working with the hole. According to Kevin Galladay, Rastani was the general contractor, and the discovery involving Rastani was still
So wait, you're saying one of the witnesses said there was supposed to be some work at some point done in the hole, right? Doesn't our case law say if you create a hole, you've got to cover it? Or put barriers around it so that workers know it's there and don't fall in it?
that is the case, unless
So tell me what would prevent strict liability under 240 sub 1 under this scenario then?
this was. I mean, I'd like to point out also this was not a hole that would risk falling into a different elevation. This was something that was dug into the ground. There was nothing. It was
2.5 feet is not a different elevation?
Well, if you
Two
look
and
at,
a half feet is not a different elevation?
I believe it's a question as to whether under the undertaking, if you look at the Arazzo versus Rockaway Housing Court case in the First Department and Letlek versus Verizon, which plaintiff relies on, there are height differentials of about 2 to 3 feet that are still considered questions of fact.
Hasn't this court held that differentials of 4 or 5 inches is enough,
Of course,
depending on the facts? So 2.5 feet, an uncovered hole.
I understand, but it was fact-specific. The note of issue had been filed. We were still engaged in discovery. There was a court conference scheduled the
Wait a
day
minute, a
after.
note of issue had been filed
Had
and you were
not-
still engaged?
Not been filed, had not been
Had
filed.
not been filed.
Rastani had answered in June of 2022. The motion was filed in October of 2022, the day before the first discovery conference was to be held. That would
Tell
have
me
included
what,
Rastani.
what in your papers points to something missing that would be in the control of the plaintiff rather than the defendants that would warrant a finding that more discovery is necessary?
Well, 32.
What did you point to? Don't tell me what the rule is. I know what the rule is. Tell me specifically what you point to in your papers that you are unaware of, that you require additional discovery in order to defend, because then we can hear you.
There are 2 inspection reports that are attached to our underlying opposition and are part of the record on appeal that are from the date of the accident, including the shift of the accident, that don't note any deficiencies in the ground or lighting deficiencies. One of the reports was written by an Alexis Apizatis of Rastani, who, at the time that the motion was filed, we had requested his contact information.
The discovery didn't relate to the third-party actions?
It is related to the third-party action, but the third-party defendant was the general contractor who was attributed with the creation of the hole and the work that was being performed at the site. They're the ones that controlled the information regarding what was being performed there.
By the way, what were the lighting conditions at the scene?
The lighting conditions were that they were poor. However, both Galladay, the foreman who testified as plaintiff's witness, and plaintiff himself testified that the lighting was sufficient to perform the work that had to be performed.
So if the lighting was deficient, does that play a part in whether this hole is something which required the protections of 241?
Well, the lighting condition go to 241-6, but that was not decided by the underlying
I'm not
court.
talking about 241-6. Does it play a role in a 241 analysis?
That is, I would argue that since plaintiff and his foreman testified that the lighting was sufficient to do what they needed to do, then the lighting was sufficient and is used to dramatize the accident.
But the question is whether the lighting was sufficient to see the danger.
I was just trying to get to it. I think that that's part of a fact evaluation that needs to be determined.
Counsel, wasn't the only working lamp 50 feet away from this hole?
That was the testimony at the time that the motion was filed.
Is there any testimony to dispute that?
I can only say that the testimony that was obtained to call the lighting issue to question was obtained after the motion was decided with the continued discovery from Rustani, which is not part of our record here today.
All right, you'll have time on rebuttal.
Good afternoon, may it please the court. At the risk of Justice Manzanet having stolen my thunder,
I'm sorry.
the only thing that defendants point to with regard to the prematurity issue is that additional depositions may have determined the why this hole was uncovered, even though it was covered with the tarp. The record itself actually says why, actually gives the why. The hole was one that was supposed to be, where anchors were supposed to have been dug in order to support the wall of the walking area of the Henry Hudson Bridge. That's in the record. That's the only reason that they provide as to prematurity. The rest has to do with second, third-party defendants. Justice Krause down below went over this in quite some detail and cited to the 4 First Department cases that are directly on point as to a hole that's 2.5 feet deep, 18 inches wide, 3 feet long. Defendant's own engineer actually testified that this kind of hole would be considered a hazardous condition. That's on page 771 of the record. And the defendant's engineer also testified he was not aware of any need for a plastic or tarp-like material to be on the ground, and that would have required pre-approval from TBTA, and in any event, that kind of tarp over that kind of hole would not have been recommended. That's on page 7.
Were there any safety devices provided to your client?
Well, he was provided with a harness and a lanyard. He wore it. Once he got to the place where he was supposed to do his work, then he would have tied off to whatever hook, whatever location he could have tied off to. He was carrying plywood to that location at the time in the dark over this tarp, never had seen the hole before.
Wasn't it his first night working night shift?
It was, I'm not sure if it was his first night, but it certainly was 10 p.m. at night. To the extent that the lighting conditions may figure into this, I submit that they might, but it's not necessary as to the lighting, to Justice Friedman's point. Even if this was broad daylight, you have a black plastic tarp over an uncovered hole.
And it's underneath, they are creating a pedestrian path underneath a bridge. So the bridge is casting shadow over their work area.
Yeah, and the one other point made in the appellant's brief is that, well, he could have walked around the hole. It's 10 o'clock at night.
You got to see the hole to walk around it.
Yes, and the pathway is 3 to 5 feet wide over this, and he had never crossed it before. Certainly, these kinds of covers are required to be not only covered with plywood, but the plywood has to be affixed to it. So, if there's any other questions,
Thank you.
thank you.
All right.
I just would like to maintain that the question of fact existed at the time as to whether or not covering that hole in any different manner would have been impractical to the work that needed to be performed at the time.
But under 240 sub 1, that is not the issue. The primary issue is the safety of workers. So that if the construction work takes a little time because of the safety we have to employ, that's what you're supposed to do.
But there's also case law that supports the fact that if the work is in progress and it's impractical to cover it, then there's a question of.
And what did you show in your submissions that there was work in progress in that hole?
Well, the problem
Because
is
you're
that the
saying-
discovery
saying
that
that-
was being was outstanding was from the company creating the hole. So it's unknown. That's the question of the prematurity issue, is what was there to be discovered about the hole could have been covered and should have been covered. I'm not saying that plaintiff could never have been entitled to 240. I'm just saying that at the time he was awarded it, the record was unclear and it was premature. The proper course of discovery should have been completed before he was given the award on this one.
Thank you so much.
Thank you.
All right, and I'm sorry to the case I called out of order, People versus Gabriel Roas. Apologies to you both. You may proceed.
Thank you, Your Honor. Sylvia Lara Altrider of the Legal Aid Society on behalf of the appellant, Gabriel Rojas. May it please the court. The record in Mr. Rojas's case does not affirmatively demonstrate that his plea was voluntary, knowing, and intelligent. As a result, his conviction should be vacated. If there are warning signs that someone is not competent to plead guilty, the court is obligated to inquire into his competence to proceed.
So what is it about, go ahead, please, go ahead.
I was just going to ask how this is preserved before we even get to the merits.
It's not preserved, Your Honor. We're asking the court
So
to
you're
reach it.
solely requesting interest of justice.
Yes, Your Honor. There was another.
What
Warning
indicia?
signs,
Yeah.
I'm sorry. What were the warning signs?
The court had a report from cases that described how Mr. Rojas had been psychiatrically hospitalized 50 times in the previous 5 years.
Counsel, in this state, and probably the whole country, criminal judges encounter defendants before them who have a myriad of mental health issues. Are you suggesting that with everyone who has any mental health issue, the court has to go through a prescribed litany of questions to make sure the person is okay to proceed without any other indicia, like a 730 exam having been held?
No, Your Honor, but I think in this case in particular, the incident took place in the psychiatric emergency department. Mr. Rojas, when he starts to decompensate, will go to the emergency.
What takes place during the allocution for the plea that creates doubt about the competency of the defendant to take the plea?
It is the absence of any inquiry into whether he is competent to proceed when the court.
So again, you're saying, you said no, but that argument then is saying that every single judge on every single case and every plea where a defendant has a mental health background has to go through a specific litany to question the mental health status of a defendant, and there is no case law that holds that.
So the Supreme Court has said that when there are warning signs that somebody is not competent to proceed, the court is supposed to
So
inquire.
I mean, that warning sign is that this crime takes place in a psychiatric ward. That's the warning sign.
That, along with Mr. Rojas's mental health history, also
Any
Mr.
indicia whatsoever that there was anything during the time of the sentencing which would indicate further inquiry was required?
So, for example, at Mr. Rojas's sentencing, which was several months after his plea, his own lawyer says, "I didn't recognize him when I saw him at sentencing," which suggests, he makes a comment about how when the mind gets better, you start to look better, which suggests that Mr. Rojas, when he appeared at his plea, in fact, did not look prepared to proceed.
Did his counsel make an application to adjourn the sentencing in order to have his client looked at because he didn't look the same?
No, Your Honor.
Okay, so the defense counsel makes no request of the court for any kind of relief out of this concern of how their client looked.
No, Your Honor.
So isn't the onus in the first instance in the person who knows the client best?
The court also has the obligation to inquire, and
Yes, but there has to be something. So tell me what happened at sentencing, right? That would have alerted the court that they had to do something.
so at his plea, Mr. Rojas, in addition to the other things I've mentioned, there was somebody from Cases, from a mental health program that was at his plea saying that he would need daily psychiatric treatment, and the premise of the plea was that he was being mandated to intensive psychiatric treatment. There was a mental health professional there saying that he needed help.
Okay.
Counsel, didn't that case rep also say so far he's doing good, he's involved, engaged in our substance abuse program? Didn't that case rep also say that?
At the time of his plea, I believe Mr. Rojas was still incarcerated, but his progress reports once he was released to Cases were positive he was actively engaged in the
So
program.
where's the warning sign to the judge or the lawyer? Something's wrong here. Question further.
At the time of his plea,
But it's not, it's at the time of sentence, right?
no, we're asking for his plea to be vacated because the plea was not voluntary. And at his plea, that is the point.
How is his plea not voluntary?
Because so the record is supposed to affirmatively demonstrate that Mr. Rojas' plea was knowing and voluntary. And here, this was somebody who had no criminal record, who was suffering from schizophrenia, who had been psychiatrically hospitalized 50 times in the previous 5 years and had recently been in a psychiatric emergency department. The court regularly, to your point, asks standard questions about whether people who are that mentally ill are ready to proceed, and there was no such questions here.
Okay. All right. You may proceed.
Good afternoon, Your Honors. May it please the court, Jacob Marcus for the people. As an initial point, to turn to Justice Kern's note about preservation, this shouldn't be taken up in the interest of justice. Not only did defendant have 9 months to withdraw or otherwise object to this plea, but this is now 8 years later that we are hearing this appeal. If it were to be addressed in the interest of justice and the conviction vacated, the people would suffer extreme prejudice in our ability to re-prosecute this case. To turn to the merits, defendant's plea was knowing and voluntary, and the
Counsel, and he had counsel with him, correct?
that's correct. Counsel,
And didn't he get a better sentence? It was 6 months split with probation, and at the end, he just got probation.
that's correct. It was 5 years probation. The initial exposure was 7 years plus up to 3 years of PRS. As to the competence issue, as Your Honors noted, there were no warning signs on the record. There was a mental health professional from Cases, the judge, defense counsel, and defendant themselves. None of them asked for a 730 exam.
Counsel's argument that you have to go above and beyond when it's a case for someone with a history of mental illness and the judge has to make some kind of inquiry.
I don't think that that holds water. The mere fact that defendant had struggled with mental health issues in the past does not mean that every defendant who struggles with mental health has to be affirmatively declared competent. And the Supreme Court case that appellant cites in their brief, actually the footnote is making that point clear. I think that's note 13 in Godinez. They're saying, by no means are we saying that this has to be done in every plea case where defendants have experienced mental distress.
Indeed, even in cases where there has been a 730 exam finding that the defendant is not fit, and then later found fit, even in those instances, there is no requirement that the court allocute the defendant with regard to their current mental status if they have a new report saying that the defendant is competent. Am I correct?
That's my understanding, Your Honor.
And the court did hear from the person from Nathaniel Project as to the update on the defendant, correct?
Correct. And the fact that there was someone from Cases in the room makes this more kosher, not less. The fact that there was a mental health professional in the room and they voiced no concern speaks to the fact that the plea was knowing, intelligent, and voluntary. And if Your Honors have no further questions, we ask that you affirm.
Thank you. Counsel, you may proceed. I'm going to give you his leftover time.
Thank you, Your Honor. I'll address 2 of the points that the government raises. One, Mr. Rojas had no criminal record when he stood before the court. The deal he got, he still served 6 months of jail time. He got the maximum split sentence possible, but also there was no opportunity for him to plead to a nonviolent felony, which I think in some of these cases is standard that if you do well in program, you have the opportunity to plead to a misdemeanor. But that opportunity was not afforded to him.
Wasn't that because of the gravity of the injury? He knocked out the doctor unconscious?
It's not clear from the record why that deal was not offered to him.
I would imagine that's part of it. You know, you go to a hospital for help and you knock out the doctor in the emergency room.
Mr. Rojas suffers from schizophrenia.
I understand. I get it.
But so this was, in fact, not the best deal that he could have gotten. He has a violent felony on his record and will always have a violent felony on his record, which will have significant collateral consequences for him. And to the point about the delay in bringing the appeal, there are lots of delays for indigent defendants in bringing an appeal that are not his fault. There are delays in getting the record. There are delays in many.
We're not holding that against him. Okay.
And then, in any case, to the point about the extreme prejudice to the government, as they mentioned in their brief, there was a video of the incident, which I think would obviate their concerns about prejudice.
Thank you.
Thank you, Your Honor.
Thank you so much. All right. RDF versus Electric Red Ventures. Okay. You may proceed.
Good afternoon, Your Honors. Scott Mullen for the appellant. In this case, there's so many issues, and I know that the court is a hot bench. So let me focus on what I think are three of the key issues. The key issue to me, one of them is the right to withdraw the counterclaims. An unconditional right, an absolute right.
Counsel, why is that even appealable at this point? Because this is an appeal from the final judgment.
Right.
So how does that particular issue, the right to voluntarily discontinue, fit into the CPLR provision so that we would even consider the merits?
Right. Because even at page 15 of my adversary's brief, they point out that if we are correct, this would vitiate the part of the judgment. We would not be here if the counterclaims in this particular case, with respect to those counterclaims, there wouldn't have been a decision on the merits. So we believe it's part and parcel.
I'm sorry, you're saying if the counterclaims were allowed to be discontinued, the rest of the case could not proceed?
No, I'm saying the counterclaims were dismissed, correct?
You're saying if the counterclaims were allowed to be withdrawn, the case could not have proceeded?
No, the rest of the case might have proceeded, but the counterclaim should have been withdrawn without prejudice, based on the case law from among other people, from yourself and Justice Manzanet in the 103 3rd Street case, 315-103, because in that case, both you justices said that Harris, you cited to the Harris case in the 4th Department and said in your decision, holding that a motion to dismiss.
Counsel, assuming we switch to the merits, because I don't know if we fully resolved the issue of whether this is even appealable, but assuming we do address the merits,
okay.
What about the fact that there's a line of very clear cases from the 1st Department which hold otherwise, including
BDO and Jericho.
BDO and Jericho. And Harris does not really specifically address this specific issue. So how is that an overruling of those cases where it does not in any way say it's an overruling of those cases?
The answer, Your Honor, is that BDO and Jericho predated your decision in 315-103rd, and it also predated the 4th Department decision in Harris. And in the Harris decision in the 4th Department, the court went into great analysis of why there is an absolute unlimited right to withdraw your counterclaims.
So besides withdrawing the counterclaims, plaintiff also made a motion to dismiss the counterclaims, am I right? There was also a motion to dismiss the counterclaims.
That's correct.
Was that motion opposed?
That's the argument on the other side, and the answer is that there was a cross motion against that. And counsel who handled it below believed the cross motion to to allow it to be withdrawn, in essence, was opposition to it. And also, besides Harris, you had the Battaglia case in the Court of Appeals.
But you don't, in the cross motion, you don't address the merits of the motion. You just say, we should be entitled to withdraw it without prejudice.
That we have an absolute right to do that as
I
Justice.
understand, but did you oppose and cross-move? Did you say we oppose their motion to dismiss and we are moving to discontinue?
At trial, counsel only cross-moved. But the cross motion having been granted, if the cross motion was granted, that would have obviated the issue. And in the Battaglia case, which the Court of Appeals was a very important case, because in Battaglia, they cited with approval the dissent in the, by Justice Levine, which said there is an absolute unconditional right to withdraw prior to adversary pleading. And there is nowhere in the CPLR, nowhere, where a motion to dismiss is equated with a pleading. In fact, the CPLR in 3011 lists 6 examples of what pleadings are, and they say no other pleading shall be permitted without court approval. So I'm saying that
You're saying we were wrong in all our cases.
I'm saying that you Justice Kern, and Justice Manzanet realized that maybe BDO and Jericho, in light of what occurred in Harris, should be revisited, and you explicitly stated, in your opinion, that Harris provides holding that a motion to dismiss is not a pleading. If you
Right,
took,
but we clearly were not making that determination in this context. And I think if we were going to overrule a number of our prior cases, we would have been more, hopefully more articulate about that.
well, this
say so
certainly gives you that
explicitly.
opportunity.
You're giving us another chance.
But if in fact, Your Honor, if you really believe that's necessary, in light also of Battaglia from the Court of Appeals, then you can say that you revisited, because the reasoning in Harris is very thorough. They went through the CPLR. There's not a single section in the CPLR that says a motion to dismiss is the equivalent of a pleading. If you took a poll of attorneys, and we don't decide things based on polls, but the law is not supposed to entrap litigants and entrap lawyers. A motion is a different device.
Counsel, let me just, I hate to interrupt you, but you have a minute left, and I would like to make sure that you have enough time to
I
hit some of
appreciate
the
that,
other
Your Honor.
issues.
So moving it right along to
Okay.
reach of comedy, the subject property was in Arizona. One party was in Arizona. The agreement, the term sheet was negotiated in Houston, Texas. The parent of Electric Red was in Texas. Texas had ties to New York. New York works very hard, especially the commercial division, to attract business. But in order to get respect, you have to give respect. The first filed action was in Texas.
Counsel, that's clearly not our rule in New York, that the first filed action gets to go forward. You have to look at the case, you have to look in what context it's filed. Clearly, plaintiff was letting the defendant know that litigation was about to commence. Defendant was engaging in settlement negotiations, not telling plaintiff it was about to commence litigation, and then went ahead and commenced the litigation in Texas while the negotiations were going on. So what was improper about the court considering all those
I would
circumstances?
slightly modify that recitation, slightly.
Feel free to slightly modify it, but that explains
With Your
why
Honor's
it's
permission,
inappropriate.
with Your Honor's permission. Okay, in every one of these disputes, parties, we have to recognize the commercial realities. In every one of these disputes, parties generally know when they're coming to an impasse, litigation is a possibility. The cases say that there is a general rule. New York cases say there is a general rule, there is a general presumption that the first filed case rule should be followed, except where there are special circumstances.
Such as a preemptive litigation.
And, I'm sorry?
Such as a preemptive litigation.
Well, the alternative, interestingly, if you play out that logic, is that if somebody says, I'm going to protect my rights, I disagree with them, I'm going to protect my rights, by them saying that, the alternative is to say that someone on the other side is stripped of their right to choose what forum. Texas was a proper forum. And the
Counsel, but
Texas
you
court,
filed it.
the trial court made a mistake, if I may make
I'm
one
going to let
statement.
you finish.
The trial court said that one of the bases for denying it was there may not be jurisdiction. in Texas. There was plenty of precedent that said if you know there's a jurisdictional issue and a jurisdictional issue is being addressed by an out-of-state court, the proper thing to do is to defer pending a decision by the other court to see if there's a jurisdictional
Okay,
issue.
you
And in
know that
fact,
our
there was
courts
no
don't do that,
jurisdictional issue.
so you'll have time on rebuttal.
Thank
We
you for
don't
your
do that.
patience, Your Honor. Thank you.
You may proceed.
May it please the court, Sylvia Strower for the respondent, RDF.
Can you start by addressing the issue of whether we should even be addressing the merits of the first argument about the denial of the voluntary discontinuance?
Our position is that the order denying their motion to discontinue the counterclaims is no longer appealable because it doesn't necessarily affect the judgment, and it's an interlocutory
And
order.
why doesn't it affect the judgment?
Because all that it would do, if you reverse that order, is allow the counterclaims to be discontinued. How is that striking at the core of the judgment? You know, in order to necessarily affect the judgment, reversal of the order would require reversal of the judgment. This would do nothing. It's not even reinstating
Wouldn't
the
have any impact on what the final judgment would be in this case.
Yeah, and also the claims would be barred, right? Because of the res judicata doctrine. Even unasserted claims would be barred because the judgment has already been entered. So in our opinion, we shouldn't even be discussing this because the order is not appealable. But if we were...
I want to turn your attention to something else. There's a meeting on November 10th, right? In which you are told that defendants are looking elsewhere for money. Your response to that isn't, oh, you have no right to do that because you're bound to this term sheet and we still have an exclusivity period. So why isn't your failure to make that response on November 10th a waiver?
It was not a waiver. From the very beginning, as soon as an equity funder came up and sent a term sheet saying these are the terms under which we would provide equity, immediately RDF agent sent an email to the broker and said, but remember that the equity funder has to recognize us as the exclusive lender.
You're talking about the email 2 days later?
No, this is even before. This is even in August, as soon as it happened. And the broker said, absolutely. If we sign term sheets with the equity funders, we are going to require them to recognize. And they never changed that.
But Supreme Court doesn't decide the case based upon that, right? Supreme Court decides the case based on what happens on November 10th and November 12th.
That's right. Yes.
So, I mean, I think initially, at least, we're faced with Supreme Court correctly make that determination, which went in your favor.
Yes. And there was no waiver because they said immediately after the meeting, and they have been told all along, that they would be recognized as the exclusive lender. So sure, they entertained the possibility that the borrower wanted different terms, but that doesn't mean that they waived their right, which was repeatedly recognized, that they would be the exclusive lender on the deal.
Continue.
Just to address briefly the issue about Harris, I'm sure you realize that the case had a completely different context. Not even mentioned 3217A. It didn't, as Your Honor was saying, if you were going to reverse well-established case law about, whether or not, a motion to dismiss is a pleading, you would have said so.
When we do, we say so explicitly.
You would say that expressly. So BDO and Jericho, that's really the law in the First Department. With respect to the summary judgment motion, all of the facts were admitted by the defendants. They admitted that the exclusivity provision is binding. They admitted that the 60 days shall be extended if they are not prepared to close. They admitted they didn't comply with the requirements to close. And they admitted that they went ahead and solicited loans from other lenders.
Was it ambiguous, though?
I don't think there was any ambiguity. The provision says the period shall be extended if you're not prepared to close. And they weren't. They tell you, yes, there was a condition. We had to get equity. And they admit they did not have they didn't have the required equity by the 60th day. So by automatic operation of the terms of the term sheet, that period was extended. And there's no question that they went ahead after the 60 days and solicited other loans.
You want to address the argument raised by counsel about whether or not this action should have been stayed in favor of the other action?
It shouldn't have been stayed or dismissed. One second. The case, in this case, the court has broad discretion to decide whether in a first file action, in a 3211A4 action, they should dismiss or stay because there's another action pending. The courts are very clear in the First Department that the dates in which the actions were filed are just one factor. It's not determinative, and that first file rule is not supposed to be applied automatically. And in this case, we sent them a demand letter on March 28th and gave them 8 or 9 days to pay, to pay what they owed, what we claimed they owed. Before the time that time was up, they went ahead and filed in Texas.
And then sent you correspondence.
And
Let's
then
talk
5 minutes-
negotiation.
Exactly. 5 minutes
When were you
later.
served with that action?
They didn't serve us for 2 months. And we engaged in negotiations in good faith, thinking, okay, we'll listen to your positions. And then we wrote back and said, we don't agree with your position. We give you 2 weeks to pay. And meanwhile, the case was already pending in Texas. And we had no idea, nobody ever told us. In light of that conduct and that clear evidence that they were preemptively filing in Texas to deprive us of our chosen forum, I think the court properly denied their motion to dismiss and to stay.
Thank you. You have 2 minutes.
Yes, yes. Both sides had an opportunity to choose a forum, and the electric red people did not do anything that was improper. It's very common that when you're trying to avoid litigation, they protected their rights to go to a lawful forum, file their action, which they hoped they would never have to serve, and enter into negotiations. That's normal business dialogue. That's not a violation of any rule, statute. You don't have any vexatious litigation here. Secondly, page 15 of the adversary's brief says the reversal they seek would allow 3 counterclaims to be discontinued without prejudice. The Texas litigation is still going on at this moment. This is what comedy was intended to avoid, to judicial waste and possibly inconsistent decisions. But they themselves admit that it would vitiate part of the judgment. Lastly, with respect to summary judgment, issues of fact are throughout the issues. What did the term sheet mean when it said prepared to close? Close what? The term sheet is a non-binding term sheet that
Except as
said
to some terms.
the binding part was
Except
the
as
exclusivity part.
is binding.
The exclusivity part was binding, but the actual business terms of the loan were not binding. And in fact, what distinguishes this case from the other liquidated...
Isn't this case only about the exclusivity? Isn't the whole basis of the judgment in this case based on the exclusivity provision and the liquidated damages clause?
Well, what the trial judge did was based it on one phrase of whether the agreement expired or not or was continued, that being prepared to close, and you didn't have a term sheet yet, a finalized sheet, a finalized loan term, so there was no loan to close at that point. There are issues of fact.
That seems to make the point.
Wasn't there no loan to close because there was no equity financing in place, which
Yes.
is the requirement for the defendant to obtain?
Yes, and that triggers the question of whether an agreement in perpetuity is enforceable in New York
But it wasn't in perpetuity. It had a duration.
Well, if it says there's a continuing duty, the Court of Appeals says that then it's in essence an agreement at will. And the summary judgment issues, they rely on emails, charts, unsworn documents. Depositions were cut off. 6,000 documents were provided a week before the response was due on summary judgment, and the parties had already spent 2 months advising the court as to the deposition schedule of when the outside dates would be for third-party depositions and party depositions, and not a single deposition was taken in this case while the documents, thousands, were being exchanged before they were supposed to testify. And someone could test the accuracy of the affidavits and test the accuracy of the charts and emails. These were not simple, unambiguous promissory notes.
Thank
These were
you.
documents that needed a deposition.
Thank you so
for your
much.
patience.
People versus Twin Allen, Middleton. You may proceed.
Thank you. Center for Appellate Litigation by Molly Booth on behalf of Ms. Middleton. On February 7th of 2020, the court stated, all right, we are putting this over to March 23rd. That's for possible disposition on consent. Obviously, something.
Now, because that's a very important day. On February 7th, on that date, the people notified the defense that they were not accepting the defendant for alternative to incarceration program. And as I understand it, the defense then said, oh no, they've made the wrong mistake. Give me an adjournment to try to convince the DA to change their mind. And the court then adjourned it to March for that purpose.
Correct.
Continue.
Obviously, some things happened in March 2020, and ultimately an executive order was imposed and then lifted. At this point,
Which part is the case in during this extended period of time? Which part of the court actually has the case?
I understand it's in the ATI part.
So it is throughout this period in the ATI part?
It's being administratively adjourned,
In the ATI part. So what about the fact that there is this understanding that anything that's in the ATI part is getting adjourned on consent? Where does that fit into this?
Well, usually that consent is either clearly expressed on the record or explicit between the parties. And so while there's an understanding that if you go to the ATI part, you may need to waive 3030, there are myriad of ways that
So you're saying that notwithstanding this understanding that being an ATI means that this case is going to be getting adjourned on consent, the record has to specifically reflect that consent? That's your position?
Yes, usually, or not usually, but frequently there's a waiver form when you enter ATI that a defense counsel may have to waive 3030 for the duration of the time in ATI. That's one way to effectuate it.
So that
that
form
done
wasn't
here?
filled out here?
Not
That form
done here.
wasn't filled out here?
No, it was not. Well, there's no record of it, at least. That isn't even necessary. It could have happened off calendar between the parties. The prosecution could say, I understand we're still in the ATI part. I understand we're still negotiating. Are you waiving 3030? The prosecution could have walked in 4 months past the executive order being lifted and said, listen, we've been in the ATI part for 4 months now. You've been waiving, right? And the prosecution could have effectuated a retroactive waiver under
None of that was done here.
None of that was done here. And so the question is really, and the Court of Appeals has said that plea negotiations in themselves don't create a waiver.
Look, the entire point of the ATI part is to achieve an alternative to incarceration deal for a defendant.
Yes.
And the people clearly and without waiver explained that they were not giving an alternative to incarceration program to this defendant because of her violent history, right?
Well, yes, the people said that they weren't going to do it, and the court let defense counsel try to take another shot at it. I think sometimes defense counsel is used to hearing no several times before they get a yes. But at that point, I think that there's no reason why the clock wasn't ticking.
On that first date in March, did the DAs change their mind and offer your client an alternative to incarceration program?
Well, that first date in March never happened.
Okay.
Because of the pandemic.
Right.
But obviously, ultimately, there was no alternative to incarceration. Ms. Middleton's now on parole.
On the first date that you come back and there's an actual physical appearance, is there an offer of an alternative to incarceration program for this defendant?
No, and in fact, that's when the prosecution files their statement of readiness for the first time. And that tells me that that's the posture the court, when when the prosecution hasn't filed a statement of readiness, everyone should be on notice that you're either waiving time or you're getting your discovery ready and filing a statement of readiness. And neither of those things were happening for the 9 months after the executive order was lifted. There's no allegation of any kind of off-calendar waiver, any kind of paper waiver between the court. The court could have contacted the parties and said, are you guys waiving time? It's been—
There's nothing on the record.
Nothing on the
There was
record.
a clear waiver of 30/30 time, correct?
Correct, absolutely. And there are many ways that could have been accomplished, and in fact is accomplished every day in New York courtrooms. But in this case, it just didn't happen. And under the case law and under the CPL, absent a waiver, 30/30 is going to apply in any courtroom. These procedures help ensure that the record is clear so that your honors can review a 30/30 claim, and the legal requirement is that it's either clearly expressed on the record under 3034B or explicit in some kind of off-calendar communication between the defense and the prosecution under Waldron. I don't think that the prosecution or the court relied on Waldron. I do think that that argument has not been preserved, but even if we were going to bring that into this discussion, there was no explicit off-calendar waiver at all. That's why they didn't make that.
Thank you.
May it please the court, David Gagne for the people. The trial court correctly found that the people's speedy trial clock was stopped while the defendant's case remained in the ATI part at her request.
Counsel, where is that rule that we could go look and find that the clock stops as long as it stays in that part?
Well, the court explained in its decision that the people are not required to announce ready for trial while the case is in the ATI part.
Counsel, but again, so you're saying the people can allow a case to stay in an ATI part after they have communicated that they have no intention of offering a plea to an alternative to incarceration program. That's the whole point of being in the ATI part. So if you're not giving that offer, why should you benefit from I don't have to follow the Constitution, which is what you're saying. I get to avoid and ignore the constitutional right to a speedy trial so long as we have this farce that we're in a part that's going to give her a plea that she's never going to get because we already said that.
Your Honor, but when the people said that they would not be offering an ATI plea, the defense then said, we strongly disagree with that conclusion and requested an adjournment on consent.
One adjournment.
That's correct. But then during the time—
So I give you from February to March. Now in March, if you don't come back, and I understand that we shut down, that doesn't change the ability to contact defense counsel and say, you know, you're right, or you know what, you're not right, and we're not going to offer your client. Nothing prevented you from being able to communicate your position, the people's position, I don't mean you personally, the people's position with respect to defense attempt to make you change your mind, right? You don't get to just say, we're gonna sit in this part for 18 months.
But Your Honor, if the defendant had wanted the speedy trial clock to start running, all they would have had to have done is ask to move the case back to the general trial part. At that point,
The people could have done that too. And the people could have said 2 words, each and every adjournment, people ready.
well, Your Honor, but in the ATI part, the people are not required to be ready, so the speedy trial clock is
Counsel,
not running.
but you're asking us to ignore the constitutional rights of this defendant after the people have already expressed their refusal to offer her the very reason she's in the part. You can't say, no, you don't get the benefit of the reason you're in the part, and oh, by the way, we're going to deprive you of your constitutional rights as long as we like.
Your Honor, as my adversary noted, the defense counsels are often told no, and they may try to persist. We know that the defense
But defense counsel suggested something else, that after this case spends a long time in the ATI part and the 30/30 clock is possibly running, when it does go back to a non-ATI part, why don't the people have an obligation to have the record reflect? But counsel, you agree that while it was in the ATI part, all of these adjournments have been on consent. In other words, at this point, what we have is it goes into the ATI part. You're not granting the plea that the defendant wants. It stays there, it stays there, it stays there. You never give the plea that the defendant wants. And now when it goes back, you don't do anything for the record to establish that the 30-30 clock was stopped on consent.
Well, it's stopped on consent because it's in the ATI part. Just by virtue of being in the ATI
Also,
part.
where is that in the criminal procedure law? Where is
Yeah.
that? Where is that?
You want us to accept a court rule that ignores the law. Okay, look, a court cannot institute rules that violate somebody's constitutional rights without there being something on the record showing that there has been a waiver of those rights.
Your Honor, I will just point out.
And you don't have a signed waiver here. So you got a problem.
Your Honor, I'll just point out that the defendant, from the record, we know that the defendant insisted on pursuing an ATI plea throughout the pendency of the period that's in dispute. Because even when the people sent this case back to a general trial part, the defendant then requested no less than 4 adjournments on consent to continue to explore an ATI disposition. So it's not as if the defense said, oh, the people don't want to give us an ATI plea, or we're just giving up on that. No, even after.
Is there any
So
case?
there are
no
also
clear
times
waiver.
when there's a waiver. Defense counsel said that there is a writ form which is executed when it goes into the ATI part, waiving the speedy trial rule. So what happened about that here?
Well, Your Honor, that's not anywhere in the record that that's what occurs.
Is there any clear waiver whatsoever in any part of this record? And if so, can you point to it?
Your Honor, the waiver is the fact that the defendant, even after the people said that they would not be offering an ATI disposition, persisted in.
So you're saying that
adjournment.
because,
He
wait a
requested
minute.
one
'Cause
adjournment.
what you're arguing is that if you're not in an ATI part, you can't try to seek a settlement of your case, a plea of your case that is non-incarceratory? That's not true. You can be in any part and seek a non-incarceratory sentence, and non-incarceratory sentences occur in every part in criminal court, not just in ATI. Am I right about that?
That's absolutely right. And I'm
Okay.
not.
So the fact that she, after being sent, I'm assuming it's a she goes into another part, continues to advocate in front of a new part, a new judge, that doesn't give you an up on anything here. That says nothing.
Your Honor, respectfully, the fact that that the defendant continued to seek an ATI plea shows that during the time period that's in dispute.
Shows that if she couldn't get it in one part, they were trying to get it in another. So what?
Counsel, is there any case that holds that if you're in an ATI part, the 30-30 time tolls?
Admittedly, I was not able to find any such case. That's quite unsurprising considering that this is a relatively new part. It's pretty niche.
At the end, what you're asking us to do is to say, if you're in the ATI part, that rule of practice that adjournments there are on consent pushes aside 30-30.
Yeah, that's right, Your Honor, because the ATI part is different from a general trial part. An ATI part, when your case is in the ATI part, there's no chance of going to trial. There can only be a plea, right? This is a special part. If you want
Well, that's
a
not
trial,
true.
then you
That's
have
not
to send
true, right? Because if the people don't agree to a non-incarceratory plea, then they go to another part. So what you just said is not true. You go into an ATI part in an attempt to get a non-incarceratory sentence. If that doesn't work out, then you go to another part and take a plea somewhere else or go to trial. That's what happens. So what you're saying is not accurate. Every case that goes to ATI does not resolve an ATI.
That's correct, but while the case is in the ATI
But
part,
for all of our discussion, it comes down to whether a rule of practice can push aside 30-30.
that's right, Your Honor. That's what we're relying on. Thank you.
An ATI part has many ways to effectuate a practical rule that 30-30 is waived while a case is in an ATI part. And ATI parts, as a concept, are certainly not new to New York. There's been mental health court and drug treatment court for a very long time, and they're all in the same vein. I think that there may be times where, first of all, there's no law that supports that CPL doesn't apply in an ATI part, but also as a practical consequence, it is sometimes helpful for an ATI part to know that 30-30 is running, so discovery is going to be turned over to the defense. And sometimes when discovery is turned over to the defense, something helpful shakes loose and creates a better dialogue between the sides that helps, helps both sides.
If you prevail here, obviously the rule of practice in ATI has to change.
I'm actually not sure. I think that because it's very easy to sign a form, and I know there's no record here, my colleagues have had signed
forms. What you're telling
forms.
us is there has to be an affirmative representation on the record by the defendant that while we're in this part, all adjournments are to be deemed on consent. Absent that, the people have to be concerned about the 30-30 clock.
I think that that's the rule currently. I don't think there has to be any change. This is an unusual case. It's weird that there was no written waiver of 30-30.
Because of the pandemic, I mean, you know, COVID put it.
Sure.
Yeah.
Yes, and then I'll also note that obviously in the ATI part,
She was in the part before the pandemic.
and they asked
So
whether
that
the
form should have been signed ahead of time and we wouldn't be here.
That's exactly right. And you'll notice that on February 7th, in the ATI,
But there are no
ATI part,
appearances. There are no appearances going on, no personal appearances going on. So things may have very easily gotten sloppy about this.
that's right. But you know, if that is the case, then
We're talking about people's liberty.
yes.
Waivers should be clear,
Yes.
correct?
That's right. And before the pandemic, on February 7th, in the ATI part, the court knew to say this adjournment is on consent. And so was aware that 30-30 applied to its part.
Thank you so much. DIG SSOF Evanston versus Yen. Judge Friedman is recused on this case. And if there should be a tie, we will follow the AD1 rules and vouch another judge in. Good afternoon.
Good afternoon.
You may proceed.
May it please the court, David Zalman with Kelly Dryan Warren for the plaintiff appellant. The court below deprived appellant of more than $1.7 million of prejudgment interest that the court had previously awarded by incorrectly holding that borrower's subsequent payment of default interest under the note and loan agreement satisfied respondents' separate and independent obligation to pay interest under Section 16.
Also, how is that not a double recovery? Can you tell me that?
Sure. It's not a double recovery because for two reasons. One, the parties specifically had negotiated that under the particular circumstances at issue here, lender would be entitled to two separate streams of default interest under the documents. The parties' agreements contemplate that if the borrower defaults on the note and then guarantors subsequently default under the guarantee, then lender's entitled to two streams of default interest. One, under Section 2.2.2 of the loan agreement, borrower is required to pay default interest based on its own default of the loan agreement. And under Section 16A of the guarantee, guarantors are required to pay default interest on the amounts that...
the same stream of income? I mean, there's only a certain amount of interest that accrues on a loan. Isn't it just alternate ways of recovering that same amount?
Not under the loan documents, no. So I think it's important...
How does a guarantor have to pay more than the lender? Which is what's happening here. If the lender has a higher rate of interest because they defaulted, so they're kind of paying their pre-judgment interest in order to continue the loan, right? And that's what happened here. So I don't understand how that's not a double dip.
I didn't mean to cut you off. I'm sorry. So because the guarantee, okay, under the guarantee, guarantors have two separate
Yeah,
payment
counsel, but
obligations.
at the end of the day, a lender cannot collect more than they would have from the principal, right?
Under the loan agreement, but under the guarantee, the guarantors have an obligation that is above and beyond the guaranteed amounts. Okay, so the guarantor agreed that it would be responsible for $10 million of the outstanding principal and interest, including default interest. And that is the amount that was satisfied by the payment of the judgment. However, under a separate section of the loan agreement, the guarantor is separately responsible for default interest in addition to the amounts that are due.
So again, you're saying that this was set up so that if there is a default, the lender gets more.
If there's two defaults, Your Honor, if there's a default under the loan agreement, borrower is required for default interest, and guarantor is responsible up to $10 million of that default interest. And you're right, that is the same obligation. However, under the guarantee, in the event that the guarantor defaults, and at that point, when the guarantor defaults, there is a separate harm because the risk of non-payment increases materially and the value of the loan decreases
But
materially.
in this case, there's no dispute that there was full recovery of the underlying loan. It's undisputed.
Correct, and there's an additional amount due under the guarantee. And this case under 5000 and CPLR 5001, the second reason I will point out the court erred is because prejudgment interest is mandatory in breach of contract cases. In the Spoda case, which we cite in our papers, the Court of Appeals held that under CPLR 5001A, a creditor must recover prejudgment interest on both unpaid principal and unpaid interest, and subsequent case law has held that's true even with respect to default interest. So in the HSN Nordbank case, Judge Coate in the Southern District.
Don't we have case law that says that a guarantor's liability is a secondary obligation on the underlying debt, and the guarantor's liability cannot exceed the amount owed by the debtor? And that is precisely what is being done here. You are exceeding the amount owed by the debtor.
Because under the parties' contract, that is exactly what the parties negotiated.
All right,
And in
I
the
got
American
it. You
trading
said it
case-
3 times. You'll have time on rebuttal.
Okay.
May it please the court, Letitia Thompson of Morrison Cohen for the defendant respondents in this action. I'd like to say Judge Mazenetz-Daniels' confusion with trying to understand why this is not a double recovery has been the same response every single person to look at this case has seen. Justice Crane was at a loss, I have been at a loss, and the guarantors here, who are 2 elderly people, octogenarians, are at a loss as to why, after having paid all of the obligations under the loan, the borrower has fully satisfied the loan, paid all interest under the loan, how could they possibly still be seeking a recovery against the guarantors for the same interest they've already recovered?
So you argue that it is double recovery?
It is. There is no other explanation than a double recovery. I have tried to think about it in every single possible way. I've looked at the case law. You can see the Greenway Muse case that you guys are familiar with, CRP Extel cases. It's a double recovery. There is one debt here at issue, and the lender here is trying to recover multiple streams of interest on this same debt. They've been fully paid. They have been fully satisfied. They owe nothing more. There are decades of case law that says, hey, when the obligation has been satisfied and fully satisfied by the primary obligor, the secondary obligor obligations are eviscerated. This is a very cut and dry and simple case, and it should have ended All efforts to collect from the guarantors should have ended when the obligation was fully and completely satisfied. This is lender overreach in the worst way, and it is really a shame that they would pursue these people under these circumstances. And to sit before this court and say, hey, reinstate this judgment, allow us to go back and levy on these people's bank accounts, put a lien against their home because of a debt that's fully satisfied. That is not what the law of New York allows, and that's not what common decency allows.
Thank you.
No further questions.
So I'll make a couple points.
You have 2 minutes.
Thank you, Your Honor. In the American Trading case, the Court of Appeals acknowledged that a guarantee is a separate undertaking and may impose a greater obligation on the guarantor than the principal's obligation on the underlying debt. And the lower court's cases, the Greenway Muse case and the Emerson case, both of those cases involve facts that are not at issue here. Both of those cases involved situations where, unlike here, the plaintiff was seeking to enforce judgments that already carried post-judgment interest against third parties. So the judgments had been entered, and at some period of time later, the plaintiff sought to enforce those judgments against a third party, and the court held, well, we can't have prejudgment interest because you are already collecting post-judgment interest on those instruments.
Thank you.
Thank you, Your Honor.
People versus Paul Pisano. Please wait for my colleague to get back. You may proceed.
Good afternoon. May it please the court. My name is Stephen Preziosi. I represent Mr. Paul Pisano. Your Honor, with regards to point 1 of my brief, the speedy trial issue, there are specifically 3 time periods I'd like to draw the court's attention to. The first is June 22nd through June 30th of 2022. And I'd like to put this into context. I'm requesting that an additional 8 days be charged to the people. Here's why. The context. June 1st, there are 112 days uncontested chargeable to the people. On June 1st, defense counsel in the lower court decides to make a speedy trial motion. The motion schedule is set. Defense counsel to file June 15th. He does. People are to respond on June 22nd. They don't. They ask for additional time until June 30th. June 30th comes. The people do not file a response to the speedy trial motion, and they announce that Mr. Pisano is indicted on a felony and 2 misdemeanors. To be clear, June 1st, the people had announced readiness. We are pre-indictment. Mr. Pisano is charged with only misdemeanors. June 1st, uncontested, 112 days chargeable to the people. I am arguing that the time period from June 22nd until June 30th should be, those 8 days should additionally be charged to the people for 2 reasons. 1, the recent case in People versus Labate. This is a case that was just decided by the Court of Appeals at the end of March. I sent it electronically to the court when it was decided, I think March 25th or something. I also sent a copy to my colleague. Your Honor, the holding in Labate is post-readiness delay. We're in the post-readiness context here because on June 1st, the people had announced their readiness, and there was a delay charged to the people, or should have been charged to the people, because of the people's inaction. That was the holding in People versus Labate.
But what's the inaction here?
The inaction is they failed to answer the motion. On June 22nd, they asked for an adjournment. They asked for the additional 8 days.
Typically on speedy trial motions, as I recall from my practice, is that you have to request transcripts of the adjournments, and those typically take time. And from the time that you announced that you were filing a speedy trial motion on June 1st, that certainly doesn't give them a whole lot of time to get all those.
And they didn't need it. Here's why they didn't need it. Because the 112 days chargeable to the people as of June 1st is uncontested.
Okay.
Everyone agrees. The trial court, defense, and the prosecution. Everyone agrees. So, misdemeanors, all misdemeanors were pre-indictment. we're post-readiness context. June 1st, they announced readiness, even though all their misdemeanors are 30-30 dead. Defense files his motion June 15th. People are to answer June 22nd. They don't answer. The people's inaction.
And
They
instead
request
they indict,
additional-
right?
I'm sorry?
Instead they indict?
And they indict. On June 30th, they announce their indictment, and on June 30th, they're not ready.
Okay.
So I'm asking that's the first period, June 22nd, June 30th, please charge the people with an additional 8 days. Second period, October 20th to November 16th. Mr. Pisano is indicted. He's arraigned on August 4th. Motions are done, filed by the defense, answered by the prosecution, and decided by the trial court off record on October 13th. My time period, October 20th to November 16th. I'm asking...
The time period when...
2022.
The time period when the people have requested and subpoenaed documents and they have not been received by the people from the FDNY. That period.
Correct.
Okay.
That period...
They're responsible for
20
the FDNY not responding to their subpoena request?
They gave it wasn't just the FDNY, Judge. It was the FDNY, it was the expert
Whatever.
report.
The point is, other agencies don't respond to their subpoena, and we should charge them.
That's not why I'm asking.
Okay, so tell me.
We're post-motion decision. The trial court ruled that the October 20th through November 16th, 26 days, was not chargeable to the people because we're in post-motion and they were entitled to a certain period of time to prepare for hearings.
Mm-hmm.
The people were not preparing for hearings. They were not preparing for trial for two reasons. One, on November 16th, they announced that they were not ready. Two,
the fact that on a date they say we're not ready doesn't mean that the time before that date that they weren't preparing for trial. Something may have happened. A witness isn't available, whatever.
Here's the second reason why they weren't preparing for trial. Because pretrial hearings and trial didn't occur until May of the following year, 6 months later.
Wow, that doesn't happen in courts ever.
And here's why. 3030 sub 4, the trial court relied on 3030 sub 4. People are entitled to a reasonable amount of time to prepare post-motions. Motions were no longer pending. They were decided off record October 13th. My time period, I want 26 days, October 20th to November 16th. 26 days attributable to the people. They were not preparing for hearings. Hearings took place 6 months into the future. Trial immediately following,
There's a decision
May.
on the omnibus motion on October 20th, isn't there? And the case is adjourned to November 16th for trial.
Yes.
No, the decision was off record on October 13th. October 20th was the next date after the decision. The trial
The case
court,
is adjourned to November 16th, right?
when the people were not ready.
Didn't they file a certificate of compliance on November 15th?
They filed a supplemental certificate of compliance, and they disclosed the FDNY reports, the expert witness report, and the Molyneux information. So the people didn't need, the trial court said, post-motion, preparing for hearings. They were not preparing for hearings. Hearings didn't occur until 6 months into the future.
The people concede they're chargeable with 7 days from November 16th to December 8th.
To November 23rd. November 23rd, they file an off-record certificate of readiness. That's an additional 7 days. So the tally. June 1st, 112 days, uncontested. My additional 8 days is 120 days. August 4th through October 20th is, August 4th through October 20th is an additional 34 days that the court found was chargeable to the people. That's 154 days. The 26 days that I am now asking is 180 days. Plus, Your Honor, the 7 days that Your Honor alluded to is 187 days. They are past the speedy trial time. Third period is September 30th through October 20th. September 30th, the people disclose grand jury minutes and medical records. They never file a supplemental certificate of compliance. Never. 24550 sub 1. When there's a disclosure, you must file a supplemental certificate of compliance. 24550 sub 3. Unless you file the supplemental certificate of compliance, you are not ready. 3030 sub 5. Same thing.
Counsel, you're out of time. You'll have time on rebuttal.
Thank you.
May it please the court, Beth Fish Cohen for the people. The court properly denied defendant's speedy trial motion because all of the 3 contested adjournments were excludable under 3034A as delay resulting from defendant's pretrial motions. For the misdemeanor motion practice, there was no inaction. The people requested that the court give them additional time to get the minutes. The court granted that approval, so the entire time is under motion practice. The one where, in terms of the August or September adjournment to October 20th, that was also an omnibus motion practice when the case was a felony. This case, first of all, this court has already ruled that the people can rely on 3034 exclusions regardless of whether we have complied with our discovery requirements or announced readiness. There are 2 cases from this court cited on page 44. However, even if that were not the case, what was disclosed in the September-October time was not the medical records. Those had been disclosed months earlier. This was the grand jury minutes where we introduced the victim's medical records into the grand jury. That is not part of 24021B, which only requires grand jury minutes of a testifying witness. So there was no discovery violation and no need for a supplemental COC. For the last one, this was a green adjournment. There was a reasonable period of delay resulting from motion practice for the people to prepare for trial after the omnibus motion. This was a dispositive motion because the defendant moved to dismiss.
Counsel keeps arguing that you weren't ready, and after all, the case didn't go to hearing for 6 months. Why was that?
Well, as Your Honor pointed out, that is hardly unusual, unfortunately, perhaps, but it had really nothing to do with the timeframes that he is arguing in particular here. This first adjournment was to be ready for trial, and the additional discovery items that were disclosed, as I already mentioned, do not the motions exclusion don't hinge on the discovery, but I would point out, as Your Honor has already noted, that FDNY, for when their records for treating medically EMT does not fall under automatic discovery because it's not in the possession of law enforcement. They are not, this is not an arson case. This is not something where they are acting in a law enforcement capacity. This is not even subject to 24520 sub 1, and that is a pretty important rule that is being overlooked in this particular case. I don't think the newest Court of Appeals decision, confusing as it might be, has anything to do with this case. It is.
You said that, not us, okay?
Sorry?
So the record is clear.
Okay, well, when there's a 4-3 split and it's a little bit of a nasty decision from both sides, I will say that that really dealt with a very specific scenario when the people change their status from readiness to unreadiness and have an obligation to sufficiently explain that change in status. So that really has nothing to do with this. If there's no further questions, I'll ask you to affirm. Thank you.
Counsel, you have 1 minute.
The FDNY records. 2 things. My colleague is claiming that FDNY is not law enforcement. FDNY has fire marshals that enforce the statutes and fire laws of our city.
Yeah, but what we're dealing with here is EMT.
When
right?
a fireman directs
right?
me...
Counsel, we can talk about the
agreeing.
FDNY, but let's not talk about something that has nothing to do with this case.
Yes, it does. And here's why. It's important.
Tell me.
And here's why. They're saying we're not obligated to give those documents because they're not, FDNY is not law enforcement. They are. They enforce the fire codes of this city. When a fireman at a fire gives me a direction and I disobey it, I'm subject to criminal charges. Firemen are peace officers. Criminal Procedure Law 2.10, subsections 28 and 29. They are law enforcement, and the people are obligated to furnish those documents in discovery. 245.
Thank you so much. You're out of time. Have a great day. Thank you, Ron. Millennium Consolidated versus Bluefin Capital. Give my colleague a moment to get back. Go ahead. Go ahead. Hopefully she can hear it in the back room. Go ahead. Oh, there she goes. You may proceed.
Thank you. Good afternoon. May it please the court. I'm Alicia McCarthy with the law firm Harris, St. Laurent, and Wexler, and I represent the defendant appellant, Bluefin Capital Management. Bluefin's been sued by Millennium for allegedly tortiously interfering with a number of contracts. But there are really two main issues before the court today. The first is whether Millennium's complaint actually states a valid claim for tortious interference with contract. And just as a quick reminder, although you seem to have all read the papers for all of these cases today, the specific claim here is that my client Bluefin tortiously interfered with restrictive covenants between Millennium and Millennium's former employee, a guy named Frank Cho. The second issue is whether New York or North Carolina law should govern this case, given that given that Millennium is domiciled in and employed Cho in North Carolina. And I do want to get to the choice of law issue because it's important, but first.
Is there a distinction in terms of how the law operates on this issue between New York and North Carolina?
There is. There's a big difference.
Okay, tell me what.
Yes, and Millennium is going to try to draw your attention to to what's common between the two laws. That doesn't matter, right? Obviously, what matters is the difference between the two laws. And what North Carolina has is a presumptive privilege for employers who hire employees of a competitor. There, you cannot assert a tortious interference claim based on alleged.
You're relying on Wells Fargo to support that argument?
Wells Fargo, yes. I hope
Okay,
you
but
will all.
wasn't Wells Fargo decided in a different context because it did not involve a non-compete clause, it was a solicitation clause, so isn't that a different scenario?
It did involve a non-solicit, that is correct, but
Isn't that a different situation which is this case, which is a non-compete, so that law wouldn't necessarily even be applicable to this scenario?
it's true, but that is not the only
But wasn't that the
case
main
from North
argument
Carolina.
that you used to support your argument that the law there was different?
Not only the Wells Fargo case, though, but I also would refer the court to the Vision Air case. We cite to a number of North Carolina cases. The law there is consistent, that this presumptive privilege exists, and therefore what is required, including in the context of a non-compete, not just a non-solicit, is that in order for a plaintiff to sustain a claim for tortious interference with a restrictive covenant, they have to plead and allege and show actual malice, which is not true here in New York. So it's a much different standard. It matters a lot. There are two, on the merits of the actual, or sufficiency of the actual tortious interference claim itself, there are two things that I think are the most important to draw the court's attention to. The first one is that this is a claim for tortious interference with contract that is completely divorced from the contract itself. The complaint, they recite all these different aspects of the non-compete and restrictive covenant provisions at issue here. What they don't do is ever explain how exactly Cho is allegedly violated the covenants by working for Bluefin, and that's a real problem. Because if you look at Cho's restrictive covenants, the language, he's prohibited from doing one specific thing during his non-compete period, and that specific thing is acting as a broker-dealer, trading in fixed income securities. That's what his non-compete says.
Economically justified in getting Zhu to breach his agreement?
I'm sorry, Your Honor, can you repeat it?
Was defendant economically justified in getting Zhu to breach his non-compete?
Economically, at the pleading stage, they have not alleged an absence of economic justification. There's no allegation in the complaint whatsoever that that Bluefin hiring Cho 5 months after he left.
Let me put it a different way. Isn't it true that defendants were not economically justified in what they did, so as to take themselves out of being subject to a tortious interference with contract claim, where what they did is solely to get Zhu to not live up to his agreement with plaintiff?
Well, we should be really clear about the facts that are alleged here. The facts that are alleged is that Millennium fired Joe in June of 2021, sent him on his way, said, we don't want you to work here anymore.
With 2 years of
Several
payment,
months-
right? With 2 years of payment.
Exactly.
Yes, but that's not-
Severance agreement.
Of course, that's not Bluefin's business. He came to Bluefin months later. This is in the complaint that they made him an offer months after he left Millennium to come work for them as
But Bluefin's business is it not, that they procured Zhu, or they facilitated Zhu, violating his non-compete?
That is not what's in the complaint. What matters is in the complaint. So Mr. Boyarsky, you can read their papers. He's going to stand up and tell you what's in the complaint, but I implore your honors to really look at what's alleged. There is nothing in the complaint that alleges that Bluefin intentionally procured any
Well, you
breach
know
of these
about it.
restrictive
You're in
covenants.
contact.
They hired a guy.
Bluefin's counsel is in contact with plaintiff's counsel and with Zhu's counsel. It's not Bluefin stumbled into this.
Your Honor, I believe you're referring to the allegations in the complaint that relate to a period of about 5 months after Cho was hired, when Millennium started writing letters.
But even before he was hired, there was communication, and they were told about the agreement with.
Thank you, that's an important point. There was communication between Cho and Millennium. Bluefin had nothing to do with. It's not alleged in the complaint that Bluefin had anything to do
Bluefin
with.
provided a statement for him to give to the plaintiffs here to explain why he would not be doing anything in violation of the agreement. So they were fully aware, and he provided a statement in order to try to get the plaintiffs here to not hold him in default of his agreement or in violation of his agreement.
Your Honor, that was months after Cho went to work for Bluefin.
You're saying they didn't know?
You're
saying they didn't know?
When they hired him?
Yes.
They didn't know what?
That he had a
Brings me to
restriction.
the
Come
other
on,
issue that-
what are we talking about here? He didn't know what? The restrictive covenant, that's why we're here, right?
At the pleading stage, I don't know. I can't speak to whether or not they knew at the time they hired him that he was subject to restrictive covenants.
Counsel, but as some.
Wouldn't that be an important fact to know in a
Sure.
case like this?
Sure, but we are at the pleading stage. What
And
also
you
is
haven't talked to
important,
your client and asked that question.
if I may, Your Honor, there are 2 layers of knowledge that matter here, right? One is being aware of whether or not there are restrictive covenants at all. Second is being aware that hiring this guy would constitute a breach of the restrictive covenant. There certainly is no allegation that Bluefin knew at any point that hiring or employing Cho would constitute a breach of any restrictive covenant between him and Millennium. That's really important.
Okay. You may proceed.
Good afternoon. May it please the court, Mitchell Boyarsky from Nelson Mullins.
Was there communication with your clients and theirs about this restrictive covenant?
Your Honor, yes, there was.
And how early was that communication?
Well, there was communication for this is not just a one-time breach, but a continuing violation of multiple obligations that Zhao had to Millennium under his agreements. But there was communications to counsel in March of 2022. There was also communications between principals where the CEO of Millennium attempted to speak with a partner, Gennady Zavolich of Bluefin, in order to attempt to gather more information, and what happened was Mr. Zavlich
When you talk about a cause
stonewalled.
of action for tortious interference, where does economic justification play into that?
The economic justification by which party, Your Honor?
Well, could you argue that Bluefin was economically justified in doing what they did because they're hiring this employee? He seems like a good employee to hire. We're not acting with malice towards you. We're just carrying out our business.
Your Honor, I don't believe at the pleading stage, certainly my client wouldn't be pleading the economic justification of the defendant, but in terms of
Bluefin might be.
Was it justified? The answer is no, because under the tortious interference with the contract, the existence of actual malice, what we pled, is significant here. Millennium spent over $40 million in developing intellectual developments, trade secrets, confidential information, treating algorithms,
Why does a matter
methods.
of pleading? Why does a matter of pleading establishes actual malice? What are your allegations of actual malice?
Well, number one, the actual malice is important because it goes to one of the elements of the tortious interference claim that Bluefin induced, procured, and caused the breach of the agreement. Justice Chan cited the activities that Your Honors mentioned before about preparing the certification and the underlying decision. Preparing the certification, stonewalling the CEO of Millennium who tried to garner information to be able to have a conversation about this issue. And so the actual malice is important for, number one, the tortious interference claim, and the legal malice is really, I think, the critical term here. Does preclude under the Your Honor's prior question about the controlling law, that does preclude the application of North Carolina law and the presumptive privilege that counsel for Bluefin was arguing, because Bluefin is not entitled to some sort of presumptive privilege when it acts with legal malice, which we have pled in the complaint. And the Supreme Court's decision acknowledged that. The other point I just want to mention real briefly is that the agreements, there are multiple agreements, were already enforced. They were enforced by a FINRA proceeding. Bluefin asked that the Supreme Court stay this existing proceeding to allow the FINRA proceeding to take place and to take precedence to avoid inconsistent results. And so FINRA already determined that Zhao breached his agreements, okay? That is important, okay? Number one, for the pleading standard, not the question about the controlling law, but for the pleading standard, okay? Because one of the issues is the existence of an enforceable agreement. And what Bluefin had argued at the motion to dismiss, which was denied, is that there exists an appropriate document to consider at the initial pleading stage that conclusively disproves the claim as a matter of law under CPLR 3211A1. That issue has been decided by FINRA, which is the special jurisdiction here for these types of matters, and it's been confirmed and enforced by the Supreme Court. That was a decision by Judge Edwards, issued December 1, 2023. So we already have an agreement or agreements that have been breached. What we've alleged is that there was legal malice to interfere under the standards for tortious interference, to interfere with those agreements. And we've pled damages, and we already know, based upon that FINRA award, that Millennium has incurred damages to the tune of $27,000 that was ordered under the underlying arbitration decision. Thank you, Your Honors.
And you have 2 minutes.
Thank you, Your Honor. So quickly, I still, standing here after 2 years of litigating this case, am at a loss as to how exactly Millennium is alleging that Zhao breached his restrictive covenants by working for Bluefin. They do not allege that he actually disclosed or misappropriated any confidential information. They do not allege
You wasn't supposed to work in anything, in any similar, what was the phrase? any services which are same or similar to the services performed or provided by the employee or the company. And in response to the attempts to satisfy plaintiff that they weren't running afoul of that, defendant gave plaintiff various descriptions of what his new job would be. And in response to that, on November 15th, plaintiff's attorney replied that defendant is clearly a direct competitor with Millennium, a technology-driven broker-dealer registered with the SEC, specializing in executing fixed income securities transactions as both trade on the same exchanges in the same type of assets. So that is enough.
I want to really make sure that you all understand that Cho and Bluefin are separate parties. The allegations relating to November of 2021, those are about back and forth between Millennium's attorneys and Cho's attorneys, nothing to do with Bluefin. Bluefin doesn't come into it. There aren't allegations about any conduct on Bluefin's part until March of 2022, months after Cho had been hired. Then Millennium started reaching out to Bluefin directly to say, hey, we think that he's breaching his agreements by working for you. And Millennium heard them out, or Bluefin heard them out, rather. They had this principal-to-principal call. He said, tell me why you think he's breaching the agreements. Heard nothing other than just that he is. Our client still does not understand today how it is a breach of the actual language. And you did, Your Honor, cite to some of the language from the agreement, but Millennium has left out in the complaint the part that prohibits Cho specifically from acting as a broker-dealer, trading in fixed income securities. And what's remarkable about the complaint is that nowhere in there does Millennium allege, nor can they, that Cho's employment at Bluefin will require him to act as a broker-dealer trading in fixed income securities.
What I read, though, did not say that he was prohibited from the language you use about trading. They said anything, any services that we give and that we provide, you can't go work for a company that does the same. That's it.
And the services are defined in the agreement as acting as a broker-dealer trading in fixed income securities, and it lists the categories of fixed income securities. Millennium does not and cannot allege either that Bluefin is a broker-dealer trading in fixed income securities, or that Zhao's employment, going to work as a portfolio manager for Bluefin, is going to involve him in any way acting as a broker-dealer engaged in the sale of fixed income securities. So that's the issue. Thank you.
Thank you.
Thank you, Your Honors.
People versus Omar Campbell. Yes or no's would be.
Good afternoon, Your
Good
Honors.
afternoon.
I would like to introduce Sachi Shurikt, a member of the California Bar who has previously been granted permission to appear on this case pro hoc vice.
Okay.
Thank you.
Welcome.
Thank you. May it please the court, Sachi Shurikt from Orrick, Harrington, and Sutcliffe. In association with the Office of the Appellate Defender, I represent Omar Campbell. I'd like to focus on the trial court's arbitrary and artificial parsing of Mr. Campbell's statement, all of which was prompted by the detective's unlawful question. None of it fell within the narrow exception that the Court of Appeals has articulated for spontaneous statements that are entirely self-generated.
Let's say I agree with you. Under the circumstances here where we have a video of the robbery in progress, what difference does it make? Isn't it harmless error?
The admission of this statement was not harmless beyond a reasonable doubt, which is the burden that respondent must carry when the error is constitutional, as here.
Why not when you have it on video?
The video was not conclusive, Your Honor. The statement from Mr. Campbell provided affirmative corroboration from his own mouth that he was present in the cab and that he was friends with the primary perpetrator with the knife. The video itself is a grainy dash cam video about a minute long where Mr. Campbell's face is obstructed by the passenger seat.
You have an ID by Salcedo, don't you?
We do, Your Honor, but he told the investigator immediately after the incident that he could not identify the assailants beyond their race and their gender. His identifications later on were based on, he told investigators his own viewing of the video, where again, Mr. Campbell's obstructed. When you see him for one second.
Didn't Salcedo talk about a particular description of your client's mouth? It was a very big mouth. Didn't he say that somewhere?
That was based on his review of the video, Your
No,
Honor.
he said that to the police when he was interviewed, before seeing the video.
No, when he was initially interviewed by the investigator, if this is at, excuse me, this is at H1, page 79, and also repeated at the trial at T, page 63. He initially told the investigator he could not identify them, only their race, gender, and I think their rough age, that they were between the ages of 25 and 35 maybe. He later said in his identifications during the photo array, this is the guy that looks the most like the image from the video. And there was testimony at the pretrial hearing that he had watched the video, I think, several times.
Okay. Well, he provided it to the police, so that's not surprising, right?
He did, yes,
Yeah.
he did. Beyond establishing identity here, which is...
The video doesn't taint his identification, does it?
It doesn't taint his identification?
I mean, the fact that he saw the video doesn't, the video's coming from his cab, isn't it?
Your Honor, I think it shows that his jurors often will give
You
great
want to
credence-
diminish its value in terms of corroborative evidence, but it's valid evidence, is it not?
It's certainly still valid evidence, but if Mr. Campbell's presence had not been conceded by his own statement, he certainly could have poked holes in the prosecution's evidence of identity. They could have forcefully cross-examined the driver about the nature of his recollection.
Look, I know the reasonable doubt standard is obviously a very high standard to meet, but if in a case like this where you have a video, this is not going to meet that standard, it's hard to think of what case would.
Your Honor, I'll note the trial court itself at a sidebar, after the video had been played for the jurors and after Salcedo had testified about his identifications and made an in-court identification of the defendant, the trial court itself commented to the lawyers, this is not a lot of evidence for the jury to go on in an identification case. That's at T115. That's precisely because the video is not conclusive on Mr. Campbell's identity. The man with the knife is shown clearly for a large portion of the video, not Mr. Campbell. It's also important, I think, to review the video through the lens of the presumption of innocence, which is how the jury would have, right? If we're reviewing for harmless error, this is not a case of whether we're viewing the evidence in the light, most favorable to the prosecution. And beyond identity, the statement also tied Mr. Campbell to the other man as a friend, which the prosecution recognized the value of. They repeated that exact descriptor more than 50 times in their closing argument, even asking the rhetorical question to the jury, how could he possibly have been scared? How could his duress defense, once he took the stand, possibly have been credible if he referred to this man as a friend weeks later to a detective? I'll finally point out that if this statement had not come in, it's perfectly plausible Mr. Campbell would not have testified at all. Once he concedes it's him in the cab, you have the video, he has to essentially explain himself. He could have not testified. Once he did, that opened the door to his 2 YO adjudications coming into evidence, and it allowed the prosecutor to argue that he was predisposed to commit this precise kind of crime, a robbery. I think it's certainly possible all of these cascading effects could have contributed to his conviction, and the respondent has not carried the burden to prove harmlessness beyond a reasonable doubt.
Thank you.
Thank you.
You have 5 minutes.
Good afternoon. May it please the court. Jonathan Sklar for the people. As your honors pointed out, the statement is rendered superfluous because the video demonstrates defendant's active participation and even orchestration of the robbery.
Well, is your adversary's statement that the clarity of the defendant's face is not so clear, such that the statements now become more pertinent to the analysis?
So the quality of the video may be accurately described as somewhat grainy, but you see a picture of defendant's face, and the duration doesn't really matter because you can press pause and view it for as long as you want to.
Was that grainy face used to create a wanted poster?
I believe it was.
I thought that's what I read in the records. So was that the same grainy photograph that was used in the photo array?
I believe it was, Your Honor, but it's grainy, but you can clearly see. I mean, I'm sure you watched it, and the jury watched it, and you can clearly compare the video with the defendant sitting on the stand. Not to mention the defendant admitted that it was him in the video. Not
that goes to your adversary's argument that but for the court's error in not suppressing the entire statement, okay, he was forced. He had no choice but to testify at that point.
Sure, Your Honor. I've two responses. One, we really don't know why he testified. That's not part of the record. And two, he set forth a duress defense, which is an affirmative defense that requires defense to establish by preponderance of evidence. So he really had to testify to prove that duress defense. So
he had to testify regardless.
Correct, Your Honor.
But if there was no, let me push back a little. If there was no statement admitted, then he could have gone with the defense, it wasn't me.
Your Honor, respectfully, he couldn't because the video shows him. So putting aside his identity,
Okay.
at 15 seconds, it shows him without looking at his accomplice, tap his accomplice on the knee or the leg, and his accomplice, without physically reacting to the tap on the leg, starts looking for his phone, clearly showing that he had that was planned in advance, and that defendant was the one setting all of the events in motion. So the duress defense is completely refuted by the video. I know they say we make too much of the tapping on the leg, but when you watch the video, it's actually quite striking how involved defendant was. So to wrap up, Your Honors, we don't think there was error here, but if there was, the video demonstrates defendant's active participation and renders the statement that was admitted completely superfluous. So we ask that you affirm. Thank you.
Thank you.
A few points, Your Honors. First,
I'm giving you his extra 30 seconds he left over.
I appreciate that. There was a wanted poster. It did not make it into evidence in this case. It was not considered by the jury.
Okay.
The tap, I do think respondent makes far more of it than there is. You can tap
But the jury considered it, right? And the defense had equal opportunity to argue that it didn't mean what the people said it meant, right? So why isn't that fair game?
They do, Your Honor. You can tap someone's leg to get their attention for all sorts of reasons. Interestingly, the prosecution asked during cross-examination of Mr. Campbell, is that you tapping his leg? Of course, he says yes. They do not ask, why did you tap his leg? They did not want to know the answer. They recognized this was a generally innocuous movement that you could impose all sorts of nefarious interpretations onto, and they wanted to leave the room open to argue to the jury that this was Mr. Campbell being the architect of this entire
Nothing
robbery.
stopped the defense from asking that question, why did you tap? Did you? Did someone ask him after the prosecutor left that question out? Did you get up on redirect and say, Mr. Campbell, tell us why you tapped him on the leg?
Fair point, Your Honor. I do not think that question was asked on redirect.
Okay.
All told,
What happens in the course of the robbery? So the knife is held to the cab driver by the co-defendant, and then Salcido turns back with money, doesn't he?
yes, he grabs money from the
who
console.
takes the money?
Mr. Campbell accepts the money when it's handed back over at him. He testified that he felt that he had no choice but to accept it. This was a fast-paced incident. And as soon as that comment comes into evidence that he's friends with the other man, it completely undermined his duress defense that he, in fact, felt completely shocked in the moment. It's viewed through an entirely different lens as soon as...
So shocked that he felt he had to take the money?
Your Honor, he felt he had no choice in the moment but to accept it and get out of the cab. When he had a huge knife inches away from his face, another man obviously being the aggressor...
I thought the knife was on the cab driver.
It was
Seems
on-
to me he could have opened the cab door and gotten out of there.
Your Honor, it was on the
Without
cab
taking the
driver in
money.
between them, yes.
Without taking the money. He could have gotten out of the cab without taking the money.
Yeah. I mean, he could have said, I ain't down with this. I'm not a part of this. I'm out of here.
He could
and
have
jumped out of the cab.
I'll note that had this statement, again, conceding his presence, not been admitted at all, he would not have, it's certainly possible he would not have taken the stand at all. He could not have advanced this duress defense then, which again allowed the prosecutor to bring in these negative facts about his past and to argue he had a propensity to commit this exact sort of crime.
Thank you.
I see I'm out of time. Thank you.
Thank you so much. West 125th Street versus Chosen Realty Corp.
May it please the court, my name is Nathan First. I represent the plaintiff appellant and the third-party plaintiff appellant. The court is familiar with the record and with the briefs, so I just want to touch briefly on a couple of points that I think are, I don't want to say dispositive because that's the court's purview, but important. I think the record demonstrates that there was wrongdoing by Riverside. I think...
Let me get more direct to the first point, which is we dismissed the complaint against Chosen in a
Yes.
prior decision.
Yes.
Now that we have done that, why isn't any claim against Riverside and Old Republic now moot? Because the only claim you have against them is for indemnification for your own liability, and since there's already been your own liability vis-a-vis the plaintiff, so there's already a ruling that there is no liability, what left is to be determined vis-a-vis Old Republic and Abstract?
Exactly the point I was going to reach. Sadly, the case below is still in existence.
Because of annex.
I'm sorry?
Because of annex.
Exactly, exactly.
But any liability at this point is hypothetical.
I don't-
So let's say somehow, any liability, there still may be liability vis-a-vis Onyx, but that you don't have a claim asserted against Old Republic or Abstract for any liability that could result from Onyx. You only have a claim for any liability that could result from plaintiff. And although the complaint could be amended or something could happen theoretically, there's nothing concrete right now to go forward. And obviously, if something changed in that respect, you could move to amend. But what live controversy exists right now as between your client and these two defendants?
If the case is renewed by plaintiff,
If.
because this, but it has 2 months and 2 years and 8
But if it
months.
is, why wouldn't you then make a motion to amend, to reassert those claims? I mean, we're not here to give advisory opinions.
If I had leave of this court to reassert those claims and to replead them if there are any technical deficiencies, then I would agree completely with Your Honor, but I was not given that by the court below. I agree that presently,
So your only argument as to why the claims are not moot is because something may happen below that
something
will then
is
bring these
happening.
claims back alive. But there's nothing now.
well, there is still the cross-claim of
I'm
Onyx
going to
against
ask you
me.
about that in a second. But with respect to that cross-claim by Onyx, that has nothing to do with your claim for indemnification against these two defendants.
No, I disagree.
Does it?
I disagree strongly because at the COVID closing, with which the court is familiar,
Go ahead.
we gave Riverside the complaint of easement. Riverside clearly was the agent.
But let me interrupt, because the only claim that you have asserted at this point for indemnification is for indemnification against any claim by plaintiff. You have not yet asserted in this action any claim for indemnification if you are ultimately found liable to Onyx. Have you?
Your Honor is correct.
So that, whether or not the claim, and I want to ask you about that, but whether or not the claim of Onyx against you goes forward, that's not going to affect one way or another whether or not there's any live claim right now that you have against these two defendants,
Well,
correct?
I would have to seek amendment below to bring them.
If and when something else happens.
Exactly, but if I may, Your Honor, presently I'm precluded from doing anything because both of the third-party complaints have been dismissed, and absent some relief from this court, I will be precluded in futuro from doing so, and I disagree.
Okay, you're saying that, but I don't know, nothing precludes you from doing something in the future. It's only based on the current. But right now, the only claim that you're still involved in is the claim with Onyx, the cross claims by Onyx. Is that correct?
That is absolutely correct.
Okay, so let's talk about those. Go ahead.
Why would you be incorrect in saying that your claim is dismissed based upon the current record in which there is presently no claims pending against you?
No one would be happier than I to buy the event and to let the 2 years and 8 months go by with that incident, in which case everything would be time barred and this would be moot. But if the plaintiff repleads because this court's dismissal of the complaint was not in its entirety, it was only against my client, and it was based on deficiencies in pleading, and it was not substantive as I read the decision.
But we can't give an advisory opinion about the future. But let me go back to my next question, which is we still have to decide the summary judgment motion vis-a-vis Onyx. Why, and I know Onyx is not here and is not opposing it, but you still have to make your claim. Why should we dismiss the cross claims of Onyx against you? And from what I understand, they're based on the provision in the assignment of the easement or the sale of the easement that you would notify in the deed that this easement existed, or the sale of the easement. Why isn't that still a viable claim that can go forward?
Because we gave at the closing the easement to the plaintiff's agent, which had been and was also the agent for Onyx.
Is that your only, and I understand that's your argument, is that the only argument you have as to why the cross-claim of Onyx should be dismissed? Is there any other argument you have other than that argument?
Onyx suffered no damage. It was enriched. It got $6.5 million for the assignment of the contract
Right,
to the
but
plaintiff.
if and when Onyx is held liable in the underlying action, won't there be separate damages, separate and apart from the sale? Because they're basically asserting an indemnification breach of contract claim. If they're ultimately held liable to the plaintiff because you didn't disclose to the plaintiff as you promised to do so in the sale of the easement, why wouldn't there be liability for that? That would be a viable claim.
Well, as I stated, because I believe Onyx was enriched by the transaction and not damaged by it at all.
Okay, so those are your two arguments, enrichment and that you gave the information to the agent.
Exactly, estoppel if the court will.
And Onyx has a claim because Riverside is regarded as its agent?
There is no claim by Onyx against anyone except me, against
Right, but
Chosen.
you want to get to by saying Riverside is Onyx's agent, right?
Correct.
So, because you're saying that as it's a rule of law, that an abstract company is not only the agent of the purchaser who retains the title closer, but it's also an agent of the purchaser, of the seller.
No, I was the seller. Chosen was the seller. Chosen had a contract with Onyx.
Onyx is the assigner. Onyx
is the
assigns,
purchaser,
right?
assignor.
What creates a relationship between Onyx and Riverside, which gives you an opportunity to try to get coverage out of that?
Onyx retained Riverside. Riverside did all of the title work for Onyx, and at the last
So
minute...
who did West 125th retain?
I'm sorry, Your Honor?
Who did West 125th retain?
They also retained Onyx. They stayed with the same title, with the same abstract
You don't
company.
mean Onyx, you mean abstract. You just said they retained Onyx, you didn't mean.
Oh, I'm sorry, Your Honor. Onyx retained Riverside, and upon the assignment, which was,
Assuming they both retained Riverside, but they
Yes.
both actually physically retained Riverside.
well, they would have had to have, because otherwise Riverside could not have performed services for Onyx nor for the plaintiff.
Well, when you have a typical transaction, if you're talking about buyer and seller, it's the buyer who retains the title company, right?
And Onyx was the initial buyer.
Okay.
Thank you.
Good afternoon, Your Honors. May it please the court, Bill Sevis, for respondent, Old Republic. We've already addressed the mootness issue. This appeal is moot. I would just add
What
that.
about the argument that things may change down below based on the next steps in the litigation?
Well, I was about to say, Your Honor, that they haven't demonstrated that the exception to the mootness doctrine, which, according to the Court of Appeals, has to, a moot issue is likely to occur. They haven't demonstrated that. They say possibly. That's not likely. It has to be substantial and novel. This issue is not substantial or novel. And it has to be an issue that will typically evade review in the courts. So those three requirements have to be satisfied.
And what do you have to, I noticed you didn't say anything about that last one. So how,
Well, they haven't
does this
demonstrated.
not evade review if it's dismissed and then something happens below and he's unable to reinstitute the claims?
Oh, well, let's grant that issue may be satisfied, but
Okay.
all three have to be satisfied for the exception to the mootness doctrine to apply. Appellant hasn't satisfied or hasn't demonstrated that any of those things apply.
Can I ask you something that has nothing to, it's not part of the record, but is Onyx still litigating this action? Is it still present in the case, just not opposing the summary judgment motion?
As far as I
I
know,
know it
Your
didn't
Honor,
appear in the appeal, but
as far as I know, the action is pretty much dormant right now. There's nothing happening. Okay. So.
should have asked you that, but.
Nobody's really litigating as far as I know, but getting to the substance of our motion to dismiss, and we respectfully ask for an affirmance because the trial court did get this right. We moved based on three grounds, each of which individually supports dismissal of the third-party complaint as against Old Republic. Number one, the plaintiff's claim against Chosen was for fraud. Old Republic cannot be liable under indemnification to Chosen for its own alleged fraud. Chosen is the alleged perpetrator of the fraud and is looking to Old Republic to make it whole under indemnification. That's just not possible. Number two, Chosen and Old Republic are not in privity. Old Republic is the purchaser's title insurance company. It's not in privity with the seller. That's just typical of all real estate transactions. Old Republic did not owe the seller any duty. And Chosen.
And if this is moot, we don't get to any of these issues.
Of course, Your Honor.
Okay.
That's the threshold issue that it's moot. But these were the grounds for dismissal. And we believe that the trial court correctly dismissed the third-party complaint. The third grounds, and again, each of these independently support dismissal. In opposition to our motion and on this appeal, Chosen totally ignores the first two grounds, that we cannot be liable for their fraud and that there's no privity and no duty. Totally ignores it. Focuses on the third ground, which is that whatever Riverside may have agreed to do, may have undertaken to do in connection with its telecom easement is totally outside the scope of its limited agency with Old Republic. Riverside was a limited agent solely for the purpose of issuing title insurance policies and commitments to issue title insurance policies. If Riverside undertook to take this telecom easement, which would be a burden on Old Republic's insured's title and record it, that's totally outside the agency agreement, the limited agency, and in fact would be adverse to Old Republic's interests because, that telecom easement would burden the insured's title. So Under any of these grounds, dismissal is appropriate. And again, we have to get by the mootness issue. I would just add that on appeal, Chosen basically tries to make the argument that it is a third-party beneficiary of the agency agreement between Old Republic and Riverside. Not much needs to be said about that, other than it wasn't the intended beneficiary of the agency agreement. Doesn't have any incidental, let alone immediate benefit.
And our precedent in this state, that would be a very long, hard road to toe.
Exactly right.
Thank you so much.
Last thing, it wasn't raised below that issue, this argument, so it's improperly before this court. Thank you.
Counsel?
May it please the court, Shalom Wogelarter on behalf of third-party defendant respondent Riverside Abstract. There's obviously some overlap between Mr. Sevis has mentioned already, so I won't belabor those points. As he said, mootness is a threshold issue, and we agree that the appeal here is moot. Likewise, we agree that there's no privity of contract, and likewise that there cannot be any indemnification on the grounds of vicarious liability because there's a claim of fraud. As it relates to Riverside in the appeal, Appellant's counsel raises this argument that there's some other contract, an escrow letter that he tries to create some indemnification obligations out of that letter. And as stated in our brief, there's absolutely no indemnification clause in that agreement. It's not a contract. There's no consideration for that contract. Any payment that Riverside received, it was from its own contractee. It was from the party that retained its services, which it provided. There's no unjust enrichment here. In the reply brief, it appears that Appellant's counsel is trying to now say that that the claim, which Your Honors have clearly stated so far, is clearly for indemnification, is for tortious interference, and that it makes out a claim for tortious interference. That claim is clearly not that's clearly not alleged in the complaint, and it's raised for the first time not only on appeal but on the reply, so highly improper. So for all those reasons, we ask the court to affirm.
Thank you so much.
If the escrow letter between Chosen and Riverside is not a contract, nothing is. It was consideration. Without that escrow letter, the transaction could not have closed. Riverside could not have gotten its premiums. As I point out in our papers, there are sufficient facts pled to view it as any number of causes of action, but the fact of the matter is, with reference to Mr. Sevis's statements, we cannot suffer the detriment of the agency agreement between Old Republic and Riverside without having a benefit. That agency agreement specifically says that Riverside must submit for recording documents within 7 days. They breached it. The deed was not recorded for 9 days after the telecom easement. Anyone searching the public records would have seen that Chosen owned the building while Onyx had the easement, thus enabling Onyx during that window period to sell it. But for that very peculiar delay, it was the same set of papers, given at the same time, at the same closing. There is no such situation as a 9-day gap in recording absent some wrongful activity. There is no doubt that the pleadings, as they were made, merit amendment, not presently, and I fully agree with the court. We just don't want to be precluded in futuro, which is why we made the motion for the court to take judicial notice. I know that the court does not entertain oral argument on motions, nor am I making it, but I'm just pointing out that as the procedural reality stands today, if the case below is activated, if indeed Onyx pursues its cross claims, or if in the next 2 years and 8 months, which is permitted by the statute of limitations, the plaintiff repleads or its tenant in common, MKM, starts an action on its own, we would then be the subject immediately of contentions by these two parties. Oh, it's res judicata. You can't seek indemnification, contribution, damages, or any other relief. That I do not believe is the state of the law. Where there's a right, there's a remedy. And all we want is to preserve our rights in futuro. I think that we've demonstrated that any judgment below which binds us would bar our relief from seeking any relief against these third-party defendants, even though the record amply shows misconduct by Riverside. And I will note in closing.
Thank you.
May I
We
say-
have gone over
I
and
apologize.
beyond, okay?
misread it.
Thank you so much.
Thank you. I thank the board.
AIG Property versus Arista Air. You may proceed.
Good afternoon, Your Honors. Adenine Medina from Barker, Patterson, and Nichols, representing the third-party defendant appellant, Q Forest Plumbing. The appellant here seeks reversal of the appealed order to the extent that it denied summary judgment in favor of Q Forest. I want to preliminarily point out that the third-party complaint that's against Q Forest only makes claims of common law contribution based on negligence as against Q Forest. And I point that out because there's references throughout the record and the briefing about indemnity claim. There is no indemnity claim by Q Forest by Arista against Q Forest.
You start out with saying you belong out of this because you were last at the scene 2 years before this valve went off.
Exactly. There is no dispute.
And then you had nothing to do with that wasn't your job to, what was done on the valve was not part of your assignment.
Exactly. There's no dispute that the cause of the leak was the disconnected neutral wire. There's also no dispute that Q Forest was not involved in electrical or any aspect of the electrical panel that was involved in this leak. Q Forest had not been on the property for 2 years and is also not in the business of installing HVAC system or accessing the panel that was at issue here. Q Forest had not been in the property for 2 years before this incident occurred. The record establishes that Arista employees had been at the property just the days leading to the leak.
Your company only installed the radiators, correct?
The plumbing. So Q Forest is a strictly plumbing company.
Okay.
And that's definitely particularly relevant here because there are several allegations being raised by Arista alleging that they installed fail-close valves and that was not proper and that they should have done installation work. And none of that was part and parcel of Q Forest's work. Q Forest came in as a plumbing subcontractor hired by R.D. Rice, which was the project manager, and pursuant to a larger sort of engineering design by Beck Engineering. Beck Engineering, and there's testimony in the record by Timothy Will, created or designed the engineering specifications for the entire project, and specifically as to plumbing. Pursuant to those specifications, Q Forest is hired to just install the plumbing, and then they're out. The plumbing installation was subsequently approved, not only by Beck, but by a third-party inspector, and nothing was pointed out to Q Forest to return to perform any kind of installation. And the record is replete with references as to potentially an installation issue, but there's no indication and no allegation that Q Forest was in the business or was responsible for addressing any installation issues that were pertinent to the structural or architectural design of the building or the unit.
They weren't hired for that purpose.
They were not hired for that purpose, and there's no indication of the record that they were that was part of their scope of their work. If you look at the invoices, they were strictly limited to the plumbing, and to the extent that there was some installation to do with some of the pipes that they installed, the record reflects that they did insulate those plumbing, those pipes.
Did they have any part in choosing the valves that were installed?
No, the record is very clear that Beck Engineering designed specifically what the plumbing would look like. And there's extensive testimony in the record that Beck not only had multiple individuals working in the design, but it had to go back to the board's, the building's board to get that approved. There were certain changes that had to be done pursuant to the board's directive. It had to be also in coordination with the owner of the unit. So by the time Q Forest comes in, all it does is, here's the specifications, this is what you need to do. They install it, approved multiple times, and then they leave. So to the extent that Arista wants to put the blame on Q Forest, there's no basis in the record whatsoever, and for this reason, the trial court should have granted summary judgment.
How do you respond to the oral argument statement that the court made, that where the court ruled that two competing experts raises an issue of fact? How would you respond to the court's ruling on that?
The Arista's expert is extremely conclusory. He wants to impose not only an obligation on Q Forest that is not supported by the record, he wants to suggest that these engineering and architectural defects in the building and the unit are part and parcel of Q Forest's work. That's speculation. Q Forest is a plumbing company. They came in to install plumbing. Nothing in the record suggests that they were also responsible for addressing architectural or other issues with the unit. But also, it's also speculative to the extent that it imposes a higher burden as to what the work performed by Q Forest should have looked like when it's undisputed that they were following the specifications by the engineering company.
Thank you.
Thank you.
May it please the court, John Cookson for Arista Air. The theory against Q Forest really involves what happened after the installation. Primarily a 2014 incident on this same system where the water froze and the pipe burst. Q Forest responded to that event, and in the course of it, the expert that AIG hired indicated that one of the reasons that the pipe burst was because the insulation in the cabinet was insufficient. So Q Forest was on notice that that condition existed.
Yes, but were they hired to fix that? Because you can get a report, and that's well and fine, but they can't fix what they're not hired to fix. So tell me where in the record they were told that that was part of their work.
Well, I'm referring to their being on notice of a problem and installing fail-closed valves.
Well, I would imagine that the other parties here had a copy of that report as well. And so why wouldn't Beck, who is designing this, not have employed some design elements to deal with the prior?
So that's why they were brought in as third-party defendants also.
What evidence is there that Q Gardens was responsible for what valve did or did not get installed?
It comes down to them being on notice that this particular system had an issue.
Yes, but they have to have a duty
Well,
to rectify it. So tell me what created that duty?
Well, our expert says that the installation itself was against industry standards.
And what standards are those?
Well, that's subject to cross-examination.
No, it has to be in the expert report for it to not be conclusory. And I didn't see anything specific, just a conclusory statement that it is against industry standards. And we deal with this quite a bit, like in labor law cases. And whenever an expert says it's against industry standards, we require them to be specific about what standards, specifically what section. They can't just throw that claim up in the air.
I understand, Your Honor, that, that he is not citing to a plumbing code section in his affirmation or his affidavit.
Well, wouldn't that be required for us to say that then there's an issue of fact?
I don't know if it's required, Your Honor, for an expert to have a specific statutory or regulatory section to say that the custom and practice in the industry is not to do it this way.
But you have to quote what the standard is, right? You can't just make a conclusory statement. It's like a doctor on a med mal case saying he violated what's normal and standard and not tell us what's normal and standard.
Your Honor, I defer, but I don't have it right in front of me.
Okay.
But I think there's enough
All right.
Get by summary judgment.
I cut you off. I'll give you another 30 seconds. Is there anything else you want to say to me, lest I be accused of not letting lawyers speak?
No, that's
Please.
My argument is that Justice Hagler did not err in finding questions of fact as to this particular third-party defendant.
Got it. All right. Counsel, you have a minute on rebuttal. Actually, two. Go ahead. I don't
Not
think
to
you
be
need 'em.
repetitive, but the expert affirmation referred to Arista was certainly conclusory in that it didn't refer to what the standard actually required, but also in addition to that, it entirely ignored the fact that Q Forest wasn't hired for these purposes. Q Forest was hired to install piping pursuant to specifications given to it, and at no point was it hired to perform installation or address other issues.
I mean, it wasn't responsible for the installation situation, was it?
I'm sorry?
It wasn't responsible for the installation situation.
It was not, and there is testimony in the file that at some point, the owner had hired someone else, and some other entity, some other party, which Q Forest was not aware of who it was, came in and did some installation work either before or after the initial installation. I'm sorry, after the initial installation by Q Forest. But certainly Q Forest was not the one hired for that purpose.
Thank you.
Thank you.
And last but not least, Wilmington Trust versus Nelson.
May it please the court. David Fiveson for the appellant. The afternoon is long. We've heard a lot of long arguments. The record is 1,200 pages, and I'm going to get right to the point.
Wonderful.
We look at page 989 of this record, and there is no way the lower court can conclude that that email authorized the annexation of signatures that were transmitted 4 days before with an email saying the documents need to be corrected to the guarantee. Now, this email attaches the loan document, does not attach the guarantee, says you can attach the existing signatures, which is plural. You needed to attach 2 signatures to the loan document, only 1 to the guarantee. And it says this finalized loan document. The guarantee is not annexed. You can't conclude, as the court did, that this was authority to annex the
Counsel, what
document.
about the finalized loan document, so which clearly included the guarantee, and he clearly received a copy of, and clearly did not object to for many years until there was litigation?
Your Honor, the finalized loan document was in January, I think January of 16, following this day. This is the day they had to
Right,
fund the
but that
loan.
would be the time for him to say, hey, this was not what I was agreeing to.
Well,
Not once the litigation was commenced.
the issue before the lower court was whether this document signed. I have that in the supplemental record. That was the sole
It
issue.
is signed, the question is whether it was authority.
That's correct, but the document that came in on January following years, 2 weeks later, their document recorded that that particular guarantee was changed on that date, meaning it was affixed or something happened on that
Right, but
date.
didn't he have an obligation, once he got the final closing documents, which included the guarantee, he had possession of them, to take a look and say, hey, this is not what I agreed to, as opposed to waiting years later when the litigation was complete?
There would only be an obligation if they hadn't already funded the loan. The loan was funded on December 31st. They had already committed the money. It was done. If, in fact, he had received that guarantee beforehand, then there would have been an obligation. Consequently, there was no reliance on his filing the document. And I'd like the court to just consider this. This was a non-recourse mortgage in California. The parties are in 3 different states, mailing the emails back and forward, and they want to close this loan on the 31st before the end of that year. The guarantee is a springing guarantee, meaning it only comes into play if there's a bankruptcy or something, a real bad act. This man was paying his bills all the way up until COVID 2020. And then they shut down that
Wait,
property.
but is your argument that he didn't think the guarantee would ever come into effect, so he didn't have to read it?
No.
That's what it sounds like you're saying in a way.
What I'm saying is that he didn't, there's no question they were not authorized to attach the guarantee on that date. Whether he should have raised that issue after allegedly he got a copy 2-3 weeks later was not the issue below, but there's no estoppel. You can't fault him because there was no reliance. They had already funded the loan. This only comes into play when there's COVID shutting down that property. The obligor can't make the payments, and they go into bankruptcy. Now we're in New York, and everyone's looking at all these emails going back and forth, and they're saying, he never authorized this signature. It's done. It was never authorized. There's no evidence of it. And Judge Kern, the issue that you're respectfully raising is maybe an issue. They may want to claim that was not the issue that was being tried below, and it's a non-issue, I respectfully suggest, because the money was already funded. There was no reliance on his
He had no
inaction.
obligation to ever bring up the fact that.
I'm sorry, Your Honor?
He had no obligation to ever bring up the fact that what was used was not authorized.
Well, if he had seen it and
Just
brought it
could
up,
stay silent and say, hey, I never authorized this, but I'm going to keep this a secret, that I never authorized it.
well, I wouldn't say he was keeping it a secret, and I'm not disputing there shouldn't have been an obligation. But however, we're now post-COVID, the obligor files bankruptcy. Now they're going after him on the guarantor.
How would they know he didn't sign the guarantee?
Because there was no, I'm sorry?
And that he didn't read it. How do you become a guarantor on a document making you liable for someone else's default and you don't read it?
Your Honor, that guarantee was still in negotiation. Initially, we had sent our comments back and wanted very important provisions changed. And then
Did
there
you
was,
follow up to see if they were made?
no, there was radio silence, and because, and I see I'm out of time, I'm gonna pass to my adversary, because the issue of the guarantee was not what they were focusing on. It was a springing guarantee. No one ever thought that there'd be a bankruptcy, that there'd be a COVID, and consequently, it was not significant at the time. What was significant,
Sophisticated parties, counsel, see where we are?
okay.
All right. You may proceed.
Good afternoon, Your Honor. Jeffrey Vanacore from Perkins Coie on behalf of the respondents. May it please the court. I have 7 main points I'd like to make, and I'll make them very quickly, probably about 20 seconds each, so I'll probably do about half my time. The first point, and 4 of these points, Justice Ostrager actually explicitly noted in his decision. The first point is that Mr. Nelson, an attorney licensed to practice in California, licensed to practice before the U.S. Supreme Court, had practiced for over 40 years, had his own sophisticated counsel in this case, and his own sophisticated counsel issued an opinion letter saying, I have reviewed the guarantee and I approve the guarantee. And Mr. Nelson is copied on that letter. He doesn't dispute that he got the letter. That point alone is reason to affirm Justice Ostrager's decision. There are 6 more points that in and of themselves are reasons to affirm Justice Ostrager's decision. The next one is the loan agreement. The loan agreement, as Your Honors correctly noted, mentions the guarantee. It explicitly says the guarantee is required. If Mr. Nelson had an issue with this, the time to do that is before you take the $8 million. To jump up and down and say, wait a minute, stop everything. This is crazy. I didn't sign this guarantee. He didn't do that. He took the $8 million. The next point, Your Honor, is that 2 weeks, Your Honors, the next point is 2 weeks after, a paralegal for the lender emailed all of the loan documents to all of the parties. Mr. Nelson acknowledges that he received that email. That would be another time to say, hold on.
But he didn't
wait.
open it because he didn't recognize the name. He didn't open it because he didn't recognize the name on the email.
The name was of the paralegal at the law firm that represented the lender. I suppose, Your Honor, that anything
I'm not saying it decides the case. But
absolutely. I would say that if you get an email that says, closing documents, that's an email that you should open. Or you should at least email your lawyer and say, hey, I got this email. Is it spam? What is this? I have some questions. So that alone is yet another point. Next, and probably most decisive, is the pre-negotiation agreement. So when this case went into bankruptcy, and this is related to a bankruptcy pending in the Central District of California, when the case went into bankruptcy, the lender said, look, we'd like to negotiate with you. We'd like to have a discussion about this. We need you to sign this P&A. I know this court is very familiar with P&As. He signed the P&A that says, I acknowledge the guarantee. That would be yet another time to say, wait a minute, this is now crazy. I don't understand what's happening. I've never seen this document.
And wouldn't that document, even if there was a legitimate basis to throw into question the legitimacy of the guarantee, that document now takes away any dispute?
Correct, Your Honor. And then, unfortunately, there's also been, and Justice Ostrager didn't address this point, but it is in the record, there was a spoliation of evidence here. And that's one reason we probably don't have all of the emails, and we don't even have a complete picture as to what this 989 email actually is all about. Because during the proceedings, and I asked Mr. Nelson about this in his deposition, he admitted that he changed computers and he wasn't able to capture all the emails. So as this court knows, in these closings, there's lots of things going on, lots of emails going back and forth. We don't even have all the emails because Mr. Nelson himself didn't preserve them. So for those reasons, Your Honor, we ask that you affirm Justice Ostrager's well-reasoned decision.
Thank you.
I'd just like to hit on some of the points that he raised. The Gates email where he says, I've seen the guarantee, that was sent, they're both in California, that was sent like at 8:22 in the morning. And Mr. Nelson's email on December 31st was an hour and a half after that. So Mr. Gates could not have reviewed the guarantee that they say was the final guarantee. Mr. Gates had his draft of the guarantee. That's number one. Number two, the pre-negotiation email letter that was signed like 2020, years later, yes, that was not the issue before the law. The issue was whether or not he signed the guarantee. Now, there are defenses to that, and that was signed before the lender went into bankruptcy. They said, Mr. Nelson called him and said, look, let's see if we can work this out. They said, you got to sign this document. He says, sure. It was before they went into bankruptcy. And you know what they did? He signed the documents, and they didn't make one effort to negotiate this and get this resolved. So consequently, that issue is subject to a defense that acknowledgement is void for lack of consideration. They just said, you sign it, and then they told him, go take a hike. The other issue is with respect to...
You're out of time, so I need you to wrap it up.
I'm going to the last point, Your Honor. Thank you kindly. The point of him receiving the paralegal's version of the guarantee 2-3 weeks later, I again reiterate the fact that the loan had already been concluded. Even if he called and objected to it, there's no evidence that there was any prejudice or that there's a reliance. Counsel's reference to spoliation evidence was not below, it was not raised below, and it should not be considered. Thank you all kindly.